Are we all set?
Give it 2 minutes, 2 seconds.
Sure.
As you can see, I'm back in the Lily of the Valley rainforest today. So
You are live.
Thank you, Supi. Good morning and welcome to the Joint Standing Committee on the Judiciary. My name is Tom Harnett. I serve as the House co-chair of the committee, and today we have 3 public hearings scheduled for this morning. But I will begin by having committee introductions, and I will call on committee members as they appear on my panelist list. Senator Carney.
Good morning. My name is Ann Carney. I represent Senate District 29, which includes Cape Elizabeth, South Portland, and a little bit of Scarborough. Welcome, everyone.
Thank you, Senator. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is Northern Oxford County and 2 communities in Androscoggin.
Representative Babbage.
How do you do? My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you. Representative Moriarty.
Good morning, all. I'm Steve Moriarty from House District 45, which is Cumberland and part of Gray.
Thank you. Representative Sheehan.
Thanks, Mr. Chair, and welcome, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. And Representative Thorne.
Good morning. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in wonderful Penobscot County.
Thank you, Representative. Representative Libby.
Thank you, Mr. Chair. I apologize that I don't have video at this moment, but I should later this morning. My name is Laura Libby, and I represent District 64, which is part of Auburn and all of Minot. Good morning.
Thank you, Representative. Representative Galgay-Reckitt.
good morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland, in spite of these foliage behind me. I have no idea where that came from.
Thank you, Representative. Representative Newell.
Thank you, Mr. Chair. Good morning, everyone. I am Rena Newell, and I serve as the Passamaquoddy Tribal Representative. Thank you.
Thank you very much, Representative. And I also would like to introduce our staff that assists us, our committee clerk, Susan Panett, who helped us through all of our technical difficulties to start the day, which means we will have no technical glitches going forward. Thank you, Supi. Our analysts, Peggy Reinsch, and our other analyst, Samuel Seneft. And again, welcome to the Judiciary Committee. And again, my name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. We will have 3 public hearings this morning. I will just give an overview. We are obviously conducting this meeting electronically. For each bill, we will hear from the bill's sponsor, any co-sponsors or legislators that want to testify. And then we will go to persons, members of the public who wish to testify. We begin with those speaking in favor of the bill, then those opposed, and then those testifying neither for nor against. While the sponsor has an unlimited period of time to introduce their bill, everybody testifying after that will be on a 3-minute clock that I will run. I will show you give you a warning when you have 20 seconds left with a yellow Post-it, and then I will let you know when your time has run out at 3 minutes. And just remember that when you are a panelist and you are on the screen, if your mic is activated, everything that you say, it will be broadcast on our YouTube channel. And with that, I would open the public hearing on LD 1292, an act regarding the parental right to direct the health care of children. And I'm pleased to present or recognize our colleague, Senator Keim, to present the bill. Welcome, Senator Keim.
Thank you, Chair Harnett. Before I get started, I did receive messages from folks that they, because of the change in scheduling, that they were having difficulty getting a link to testify. Could we just put somehow for people watching on YouTube a way for them to contact the clerk so that they could do that?
I am not sure how to do that. I know we can put something in the chat.
Right, but that's all not seen on YouTube. So I think it's susan.panett@legislature.maine.gov.
That is correct. susan.pinette@legislature.maine.gov. So for those who are listening, that's the way to contact the committee clerk so that we are certain that everybody who wants to testify will be able to do so. And with that, Senator Keim, whenever you're ready, please present LD 1292.
Thank you so much. Good morning, everyone. Senator Carney, Representative Harnett, and my esteemed colleagues of the Judiciary Committee. Thank you for allowing me to introduce LD 1292, an act regarding the parental right to direct the healthcare of children. I am Lisa Keim of Dixfield, and I'm honored to represent the citizens of Senate District 18, which includes Northern Oxford County and 2 communities in Androscoggin. This bill requires the Department of Health and Human Services to obtain permission from a parent or guardian before placing an infected minor in isolation during a public health emergency. It also prohibits physical examinations, surgical procedures, vaccine administrations, and drug prescriptions for a minor without a parent or guardian permission, as well as a physician's order not to resuscitate, to withhold an artificial life-sustaining procedure, or to withhold artificial nutrition and hydration. An exception is provided for life-threatening situations or when the parent or guardian cannot be readily located or contacted. The purpose of this bill is to establish in the law, or more broadly outline in law, that parents have a fundamental right to direct the upbringing, education, and care of their children. In the absence of clearly defined statute, we leave the possibility open to medical professionals and the Department of Health and Human Services to supersede parents' rights. This bill is meant to portray legislative intent that parents be given first and highest consideration in the healthcare decisions made for their children. We should recognize that parents have the duty and the right to make the decisions they believe to be best for their child. Eye-opening examples of where this fundamental right is being eroded here in Maine and across the nation prompted me to bring this legislation. One such example is the horrifying story of 4-year-old Jackson Steinlosk, where health professionals and HHS workers surmised that Jackson's parents were guilty of medical child abuse and worked to prove that conclusion. Without any court finding, the doctors began making it difficult for Jackson to get proper medical attention. And unbeknownst to the family, one doctor treating Jackson initiated what is called patient-aligned care team and put himself in charge. He further intervened when Jackson's parents sought emergency medical treatment at Maine Med for an infection, telling emergency room docs to send Jackson home untreated, forcing Jackson's mother to drive her child to Mass General for treatment. Another erosion of parental rights comes from Washington, D.C., where the D.C. Council approved a bill allowing children from the age of 11 to be vaccinated without parents' consent. In this law, doctors determine if their minor patients meet the standard for informed consent, allows them to submit for insurer payment for the vaccine without the parent's knowledge, and to submit the immunization record directly to the minor's school rather than their parents. One DC council member stated opposition that medical professionals and schools should not be permitted to coerce impressionable minors into procedures capable of causing injury or death behind their parents' back. Unfortunately, for DC children, this reasoning did not carry the day. Further showing the need for increased parental rights protections is Simon's Law, originally signed into law in Kansas in April 2017. It is named after Simon Crozier, a baby born with trisomy 18 in 2010. As Simon neared 3 months of age, he began to decline, and to the horror of his parents, healthcare staff did nothing to help him as he slipped away. Unbeknownst to them, a DNR had been placed in his chart by the doctor. So, when we were supposed to hear this bill last week, Simon's parents were with the governor of Georgia as Simon's Law was being signed into law that day. But I'm hopeful that today they will be joining us. Simon's parents consider him to be a gift from God. And I hope that if they're not here, you will take time to read their powerful testimony, which has been submitted. In Texas, Alicia Huber of Texas also uncovered a DNR in her son's file as he struggled to survive with trisomy 18. She was told that the physician's right and the hospital's right, they had the right to place the DNR. The doctors also declined to perform a surgery that was needed to repair his heart. 11 years after his condition was declared incompatible with life, Lane Hober lives at home with his parents and 3 siblings. Lane doesn't walk or use words, but communicates with sounds and can shake his head yes or no. He laughs at jokes, he smiles when his mother reads books to him, and he turns the pages. Hober says that her son is now more at risk because the doctors declined to give him that early heart surgery. In this bill, there were amendments that needed to be made, and actually I worked with Sam to craft those amendments, and that has already been uploaded to the site for everyone to view. But in the original bill, it was not the intent to override current law pertaining to the areas where a minor may already consent to their own health services, specifically portions of Title 22 and 32 that refer to treatment for emotional or psychological problems, family planning services, and consent for sexual assault forensic examination. So that is one amendment that's been made. Another amendment is the state may have a compelling interest in quarantining a minor child to control communicable disease. However, this should not eliminate a parent's fundamental right and interest in decision-making regarding the quarantine of minor children. Therefore, a necessary amendment strikes a balance and reads that minors may not be removed from the home unless the parent consents or refuses to participate in household quarantine. Kansas also has a similar bill, and they amended their language to ensure that truly fetal care will not be required of medical professionals. In this form, it allows the healthcare providers to exercise reasonable medical judgment in determining whether an intervention is futile or medically inappropriate. The fundamental rights of parents to direct the healthcare of their children is being eroded by a paternalistic and condescending approach of the state and healthcare providers. This bill will address an important area of parental rights, that of directing healthcare. Parents, not doctors or the state, are the best decision makers for their children's health. We should safeguard those rights and not allow them to be undermined without an affirmative ruling of unfitness. The courts can determine when to take away parental rights. But until that decision is made, parent rights should not be curtailed. It is the parents who suffer the biggest impact of their child's disease or illness, and it is they who will be hurt the most by their child's death or negative health outcomes that can affect them for life. Parents are the greatest stakeholders in the lives of their minor children, and good parents will urgently seek the best health outcomes for their children through all available channels. It is for that reason parents who naturally have their children's best interest at heart should be given the highest deference in medical decision making. Thank you for your time and your consideration of this important bill, and I'd be happy to take any questions.
Thank you very much, Senator Keim, and thank you for bringing this bill forward. Are there questions from committee members for the bill sponsor, Senator Keim? Representative Moriarty.
Thank you, Mr. Chair. Senator Keim, I just, first of all, need to clarify whether the amendment takes the place of the original LD.
I am not looking at that right now. Let me pull that up and look. I can't at this moment remember if Sam Senef, who wrote it, oh, he has his hand up to answer. I don't remember if he wrote just the amendments or if he repeated the rest of the bill.
It looks like the full bill, but with amendments. So I'll wait to hear from Sam.
Sam, is that an issue you could address, please?
I'm sure so the bill, it is the bill with amendments. It's not a full strike and replace.
But the amendment represents the entire bill.
Yes, that's what he's saying.
Yes. Yes.
Thank you. Does that respond to your question, Representative Moriarty?
Well, yes, I guess for purposes of this hearing, I'll be working off the amendment as opposed to the original LD. If I may, I'll just follow up with one question, Senator Keim, pertains only to Section 1, which amends Title 22. So with regard to confining those with infections, does this apply only to minors in the custody of the DHHS, or does this apply across the board to all minors who may have, whose parents may have no involvement with the department?
The intention of the bill is that it applies to all minors who have no involvement with DHHS, because obviously Health and Human Services, if there was some sort of outbreak, and there was a need for quarantine, it would be that agency that would have the authority to kind of enforce quarantine. But it's putting the parents above HHS and saying, still, you must seek out the parents and work with them in order to come to a solution that works for children.
Wouldn't the hospital have that authority, assuming that there's no familial involvement with the DHHS for any reason whatsoever? If a child has a strange infection, wouldn't the hospital have that sort of quarantining authority?
I don't think so. I think they would have to report it and then seek authority from a government agency. I don't think a hospital could just say, you must quarantine.
Okay, thank you.
Thank you, Representative Moriarty. Thank you for your responses, Senator Keim. Are there additional questions from committee members for the bill sponsor? Representative Moriarty?
I do have more, but I was going to defer to somebody else if there were some.
I am not seeing other hands up from committee members, so you may proceed.
Okay, then I'll go on to Section 2 of the amendment. And in this instance, Senator Keim, the words registered or certified have been stricken from subparagraphs 1 and 2. And can you tell me what the purpose of that amendment is?
Yes, let me bring up. That was another thing that I worked out with Sam as he was going through the bill. So let me bring that up right now, and I will find it for you. So he removed the reference to registration or certification of individuals under the Board of Medicine because licensure is the credential granted by the board.
Well,
so I think Go ahead.
Okay. No, well, I was going to ask about, for example, a physician assistant, a certified nurse practitioner, people with higher than people who maybe not be medical doctors, but have higher level of training and credentialing. Are we removing all of them and just leaving medical doctors and perhaps DOs alone?
It isn't my intent. It isn't my intention. I think that's something that I definitely would like to work through, because I mean, I had an experience even as an adult with this where I had a serious infection, and I had gone in to see a doctor who wasn't my regular doctor, but they ended up putting a note in my chart that basically said I was a hypochondriac or something. And so when I went into the emergency room later that day to say, I'm very, very ill, you need to take care of me, the doctors read the note and they sent me home and they said, there's nothing wrong with you. So I had to go then to another hospital where I ended up being admitted for a week and almost lost my kidneys. So this note that the doctor put in was incredibly negative towards me, and I had no idea that was why they sent me away without treating me. And it wasn't until much later that they were obviously worried about being sued, that they came back to, and I did nothing with it. But so doctors can be incredibly powerful in what happens with medical treatment. And of course, I was an adult, but I can't imagine if I went to a hospital and someone wouldn't treat my child because a doctor is putting those types of notes in there. And I think it's something we really have to consider, how much authority they have in controlling the healthcare of our children over and above a parent's wishes.
Okay. Right. I'll hold for a moment. Just regroup.
Thank you, Representative Moriarty. Or Senator Carney.
Thank you, Chair, and thank you, Senator Kine, for bringing this legislation forward. I wanted to ask you if you could speak a little bit more to the changes that you made in the exceptions section, because I was concerned with the original bill that I wasn't clear how it would fit into the protections, for example, for a 17-year-old to have access to family planning services. Could you just speak a little bit more about that?
Right. So when I first worked on the bill, I with the analyst, I had stated that I don't want this bill to interfere with any of the rights that a minor already has to direct their own health care. So that was supposed to be clear in the first bill. And then, sharing it around with other folks and listening to them, it was kind of told to me that people didn't feel it was clear that this looked like it was interfering with the minor's right to get, sexual, reproductive, medical, whatever that they needed, and having that right to direct their healthcare in that way. And so this really isn't meant for that. And so we tried to craft the language so that we exempted all of that, because this is more about other types of medical intervention and parents having the ability to work with medical providers for the best interest of their children, and not having the medical providers overstep their bounds, or HHS overstep their bounds and make the decisions that really should be left to parents, especially behind their parents' back, which, some of the examples I've shown, definitely that's happened as well.
Thank you. I really appreciate you making that clarification, because I was confused originally with the intent of the bill, and that's very helpful. Appreciate it.
Thank you, Senator Carney. Representative Moriarty.
Okay, I'm back, and I'm still on section 2 of Senator Kine. This one dealing with the subparagraph 2, the unauthorized withholding of treatment. And I'm wondering whether current law would allow someone appropriately licensed to actually withhold nutrition and hydration and impose a DNR order on his or her own accord. I never knew or even assumed that that was the current law.
I think that with what I've read in examples of what's happened, that we're finding that that isn't addressed. So in the absence of it not being addressed, these decisions are being made.
Do you know if perhaps, if not in statute, if it's addressed in medical codes of conduct and professional standards that maybe a hospital or even the Board of Licensure provides?
I would assume that yes, that would be part of standard policies that are addressed under the Board of Licensure. I also believe that it's important that, you know, what this bill is seeking to do is to ensure that parents have the right, and that would supersede whatever policies the board is creating. So this would direct their policies if they needed to flesh them out further. But this would definitely direct and say, you know, you have to give priority to, you have to inform parents and be making decisions along with them and not superseding them.
Okay, well, I know we're going to hear a lot of testimony at this point, so thank you for your insight.
Thank you, Representative Moriarty, for the questions. Thank you for the responses, Senator Keim. Are there additional questions from committee members? Seeing none, again, thank you very much for bringing the bill forward. And I will now turn to the attendee room to ask persons that wish to testify in support of LD 1292 to please raise your electronic hands, and I will have the committee clerk move people over as I call them. We did have a request from someone who needs to leave quite soon to be called upon first. I'm sorry, Senator Keim, Senator Carney, your hand is up, so I keep you on the front screen. Is that right?
That is exactly right, as I'll be timing.
Thank you. And I welcome to the committee Dick Atlee. Mr. Atlee, when you are comfortable, please begin your testimony. Welcome to the committee, and my Senate co-chair will inform you when time is running down on your 3-minute clock. So proceed when you're ready, sir.
Thank you. Senator Carney, Representative Harnett, and distinguished members of the Joint Committee on Judiciary, thank you for the opportunity to express support for LD 1292, an act regarding the parental right to direct the health care of children. And I'm responding to the original bill because I haven't found a copy of the amendment yet. I assume it doesn't change the nature of
Mr. Atlee, if I could interrupt you a second. I know I'm having a difficult time hearing you. Can you get a little closer to your microphone, please?
Sure. The testimony I'm giving was for the original LD 1292. I haven't seen the amendment, but from what I hear, it doesn't sound like it affects this testimony. In a sense, the bill's title says it all, referring as it does to the parental right. Though in a different circumstance, the Supreme Court was clear in its 1972 decision in Wisconsin v. Yoder that, quote, the history of culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition, and I provided in the testimony the link to that decision. As far back as 1689, John Locke's second treatise of civil government asserted that, quote, the world is peopled with Adam's descendants, who are all born infants, weak and helpless, without knowledge or understanding. But to supply the defects of this imperfect state, till improvement of growth and age hath removed them, Adam and Eve, and after them all parents, were, by the law of nature, under an obligation to preserve, nourish, and educate the children they had begotten, not as their own workmanship, but the workmanship of their own maker. This is that which puts the authority into the parents' hands to govern the minority of their children. LD 1292 is a common sense modern application of this principle, which it combines with the post-World War II principle of requiring informed consent for medical procedures. That principle is enshrined in several treaties ratified by the United States, the Nuremberg Code, the 1964 Helsinki Declaration, and the UN's Universal Declaration on Bioethics and Human Rights. I provided a link for these as well. LD 1292 does grant the state the right to overrule this principle, but it avoids the ever-present potential of government overreach by permitting this only in extreme circumstances. It puts the state squarely in the trajectory of common law and cultural precedent. As such, it really clearly ought to pass. Thank you.
Thank you very much, Mr. Attlee. And I may have missed it in your introductory comments, but could you and all witnesses coming after this please state your town of residence?
Southwest Harbor.
Thank you, sir. Are there questions from committee members for Mr. Attlee? I am not seeing any, so I thank you very much for your testimony and taking the time out of your day to present it to the committee this morning. Thank you, sir. The next person to testify will be Heidi Murphy. Ms. Murphy, welcome, and as soon as you are comfortable, please begin your 3-minute testimony.
Hi, my name is Heidi Murphy. I want to thank you all the members of the committee to allow me to come and talk. Cheryl Crossia had asked me to come on as I have a child with trisomy 18. I just want to give you a picture real quick of what my child looks like with trisomy 18. Her name is Sejana Murphy. We were told to abort. She had 2 weeks to live, they said. She is now 3.5 years old. She was deemed incompatible with life. She was refused care due to her chromosomal disability. She'd had a G-tube, a feeding tube surgery, and after the surgery, the nurse took it into her own hands to not call anybody when Sejana's oxygen dropped to 5. She got stiff and she almost died. No CPR was performed. And then we were, I'm kind of going really fast because I only have 3 minutes. Then we went to another doctor. This was a complex care doctor. They're supposed to be there for children that had a lot of medical issues. This doctor told us we should have let her die. However, we have fought very hard and long for Sejana, and for not just Sejana, but all kids that have chromosomal disorder like Sejana. It should be the parent's choice to direct the health care due to situations like Sejana's. Another moment she had gotten RSV. We went to the hospital and I had told them she was full code. Everywhere I go, I have to tell people my daughter's full code, my daughter's full code, because if I don't, they will not treat her. There is a, and so in this hospital, she almost died because they put the wrong side breathing tube in, and then they weren't going to resuscitate her. And I had to scream, she's full code, you better do it. There is a Non-Discrimination Act of May of 2008 from President George Bush, but the doctors are not following this. They have a license to kill our children. They can refuse care. They can say, oh, you know, she's too far along. She's got too many issues. And they have blood on their hands. How would anybody, I don't mean just you, but anyone feel if this was their child and people would not treat them and just let their oxygen drop and not do anything? I believe in advocating for all children with disabilities. Sejana does have trisomy 18 like Simon. It's a life-threatening developmental disability. I'm aware of that. However, there's a fine line here. They don't want to harm children. That's what they're using. However, they're harming them by not providing the right intervention. And I'm just asking you to please let the parents make the decision for the right to direct healthcare for our children. Everyone has the right for the life and for our intervention.
Thank you very much, Ms. Murphy, for your testimony and providing your personal story. And I apologize if you did mention this, I may have missed it. Did you give us your town of residence?
I'm sorry, I didn't. I get nervous. It's Amesbury, Massachusetts.
Thank you. Thank you very much, Ms. Murphy. I will now ask if there are any committee members that have questions for you, and I will begin with Representative Thorne.
Thank you, Mr. Chair. Thank you, Ms. Murphy, for coming and providing your testimony today. We appreciate it. I'm not medically astute as I should be, I think. Could you tell us what the term full code, when you refer to that, means?
Okay, so if a regular child, okay, let's say a typical child goes to the hospital and say they have their oxygen dropped, okay, they would treat them without question. No question at all, they would treat them. But because my child has trisomy 18, which is a genetic disorder, and they deem them incompatible with life, they don't. You have to either put it in writing or yell at them like I did in a moment. You have to, that's what full code is, full intervention. You're going to do everything you possibly can to save my daughter's life. That's what it means.
And a follow-up, if I may, Mr. Chair.
Yes, Representative Thorne.
And help us understand, at what point was this in your daughter's life? How old was she?
Oh, okay. So they wanted me to do amniocentesis, and it was speculated when I was pregnant that she could have trisomy 18 or 13. However, we chose to, because we're religious people, to rely on God and wait and enjoy our pregnancy as much as possible. After she was born, I did have a birth plan. I made sure to say, do everything to save my daughter's life and mine, and that type of thing. And so they were made to do that. And also, I had talked to people that if they knew that she had trisomy 18 before she was born, then they wouldn't help her as much. So I didn't want them to know. Okay. So they did do everything after Sajana was born. And then we decided that, yes. Oh, okay, it didn't freeze. Okay, and we decided, yes, that they can do a blood test. So she was, how old was she? A couple weeks old, maybe.
Okay.
Right. Not even. And then we did a blood test, came back.
Still in the hospital, hadn't gone home yet?
Right.
Okay. At any point, did you have a conversation with the doctors about DNR or anything like that?
Well, I didn't know a lot about it at that point. I was just very frazzled. We had a team meeting and she had a breathing tube at the time. And they said, well, what if we take it out and she struggles? I said, put it back in when any other child. Well, not everybody would do what you do. Well, I had to really advocate. I had to step up to the plate. I had to tell them, this is the way it is. A geneticist told me that she'd be lucky if she lived a few more weeks, that I should just say goodbye to my child. I wasn't ready. And I knew, I have 6 children. She's my youngest. And I knew by looking at her, she was very aware of her environment. She knew what was going on. And I'm like, no way. And I kept advocating. And we almost lost her once due to malpractice. But we definitely think that parents should have the right to make this decision. And
okay, thank you. That helps.
And just one more thing. In the team meeting, the geneticist said she's incompatible with life. She'll never walk. She'll never talk. She'll never do the things that children do. I just want to point out something. My daughter says words. My daughter isn't a gait trainer. My daughter jumps. My daughter understands everything. She's been tested now. She isn't as up there like another 3-year-old. However, she's has high receptive language, which means she understands everything that's going on around her.
Thank you. We're happy that worked out for your daughter.
Thank you.
Thank you, Representative Thorne, and thank you, Ms. Murphy, for your response. Representative Libby. We can't hear you, Representative.
Thank you, Mr. Chair. And thank you for being here today, Ms. Murphy. I just wanted to thank you for being here. I have an 11-year-old that we were told was incompatible with life. So I appreciate hearing your story and thank you for being here on this bill today.
Thank
You're welcome.
Thank you, Representative Libby. And Representative Evangelos, I see your hand is up. Go ahead.
Thank you, Mr. Chair. Good morning, Ms. Murphy. I only had one quick question. Did the experience you had with the hospitals and the like, did they occur in Maine or was it Massachusetts?
It was in Massachusetts.
Amesbury's not very far from here, though.
No, it's not.
Thank you.
You're welcome.
Thank you, Representative Evangelos. Are there any additional questions from committee members for Ms. Murphy? Seeing none, again, thank you very much for taking time out of your day to testify and to share your story with the committee.
Thank you very much.
Your input. And you will probably be moved back to the attendee room now. And I would ask the committee clerk to please move Ann Sorbanis over from the attendee room to the panelists category. And Ms. Sorbanis, welcome to the Judiciary Committee. We appreciate you being here today. As soon as you are comfortable, please begin your 3-minute testimony and just be aware that the clock will be shown when you're running out of time.
Thank you. Thank you for having me here today and giving me the opportunity to speak. And thank you to Senator Lisa Keim for presenting this important bill. I am here to speak in behalf of LD 1292. And I'm also, my testimony does also, go towards in support of LD 1510, which I know you'll be hearing later. I'm a mother of 5 children, 3 of whom have severe food allergies. My kids have been going to the same elementary school for 6 years, and each year I have to fill out a small mountain of paperwork pertaining to their allergies, complete with safety plans, doctor's notes, and consent to treat in the event of an accidental exposure. With all of these precautions in place, one would assume that all of the staff who work with my children, oh, can you hear me?
Yes, we can.
Okay. One would assume that all of the staff that work with my children would also be properly trained in the safe handling of my children's allergies. Sadly, this is not the case. I've received a call from the school 6 times letting me know that one of my children was accidentally given a food that they're allergic to. 6 times. While at the school and under the care of school staff, my children were given a food that could have killed them. Each time, the explanation by the very apologetic teacher or lunch aide or substitute was, I asked them if they could have it and they said they could. To which I reply, yeah, they're kids and don't always know exactly what food they can have or what is in the food that you're offering them, which is why I specify that all foods need to be screened by myself. I am their mother. Do you know how many times I've accidentally sent or fed my children food that they cannot eat? 0 times. Because I know exactly what is in all of the foods that I give them. I know what is safe and what is not. It is my job. If I didn't, I would be considered a negligent parent. And as a former foster parent and director of a nonprofit that works with parents who have lost custody of their children, I know a thing or two about parental negligence. Kids need to know that the adults in their lives will keep them safe. This is the most basic need and the primary role of a parent. We are our children's advocates and experts. They trust us to know what's best for them. On the contrary, when a child is asked to make a decision without the consent of their parent, instead of feeling empowered, they experience an increase in anxiety because they innately understand that their ability to keep themselves safe is compromised by their underdeveloped brains and lack of true understanding of the risks involved. Children understand that they are being asked something. Like, for example, if an adult was to ask at school, a school nurse was to say, can you have this medicine? Or are you giving me permission to give you this vaccination? Children understand that they're being asked something that their parents should be answering for them. And this causes the children, rather than feeling empowered, they feel insecure and unsafe.
Ms.
Yes?
Sorbanis, that ends your 3 minutes of time. So if you could just wrap up in a sentence.
Sure, absolutely. So in closing, medical professionals and school staff, they make mistakes. They are not our children's best advocates. They cannot be. They have hundreds of children at time in their roles. Parents, that is our job. It is our job to know what's best for our children. And it's because of this that parents cannot be removed from or denied the fundamental right to direct our children's health care.
Thank you very much, Ms. Sorbanis. And could you please, just so we have the record complete, and again, I ask this of all people testifying, please provide your town of residence.
Yes, I live in Phippsburg, Maine.
Thank you very much, Ms. Sorbanis, and thank you for taking the time out of your day to present your testimony to us. Are there questions from committee members for Ms. Sorbanis? Seeing none, thank you very much again for your testimony today. We greatly appreciate your being here and sharing it with us.
Thank you.
Thank you. I would now ask that Becky Grant Wyden be moved over as a panelist. And Ms. Grant Wyden, as soon as you are comfortable, please unmute your microphone, activate your video, and begin your 3-minute testimony.
Hi,
Welcome.
good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Becky Grant Whedon, and I live in Wilton. I am the mother of 3 sons, 2 young adults, and a teen. I am here in support of both LD 1292 and 1510, but I will be speaking to 1292. When my eldest son was 4, I brought him and his brother in for their physicals with a new pediatrician in our practice. He was healthy and we were not there for any sort of medical concern. He was also newly diagnosed with autism, which can present added difficulty in medical exams beyond typical challenges with young children. The pediatrician wanted to look at his penis and my son would not comply. Did I hit something? Sorry. My son would not comply. The doctor insisted we could not finish the exam without him doing so. And before I knew it, I was forcing my struggling, fighting 35-pound disabled child onto the exam table while the doctor pulled his pants down to look at his penis entirely against his will. I knew it was wrong and it felt wrong, and a horrible assault on my son and the lessons parents want to teach their children about bodily autonomy. You might say that I consented to this, and in essence and probably legally I did. No part of me wanted to allow this. If I felt like I could say no and walk out, I would have, and I should have. I was a new mother and didn't want to make waves with this new pediatrician that I didn't have a relationship with. My point in telling you this in relationship to the bill you have before you is that if I, as a 32-year-old educated woman, felt pressured to comply when I did not consent, how can we possibly expect adolescents to have the tenacity to truly give informed consent to any procedure or examination presented to them by a healthcare provider? That day, I went back to work extremely upset about what had happened and told my boss, who also happens to use the same pediatrician and was an executive in the hospital system the pediatrician and I both worked for. She urged me to make a complaint and also told me that her son had refused the same as mine, yet was given the agency to say no by the same doctor. This is very important to stress that healthcare professionals are human and come with their own prejudices and favoritisms. You may be thinking that doctors and other health professionals wouldn't use coercion based on your own experiences. However, it can and it does. There needs to be checks and balances, and the parents need to be provided with legal protection to provide that when it comes to their child's health care. Children are not allowed to make decisions to quit school, sign up for the military, drink, smoke, or consent to sex with adults for very good reasons. For these same reasons, they are not capable of understanding the full ramifications to give true informed consent for healthcare. They have the right to an advocate that has their best interest at hand.
Ms. Grant Whedon, your 3 minutes is up. If you could just wrap up your testimony in a sentence or two.
Done.
Okay, thank you. Thank you very much, and thank you for sticking to our 3-minute clock. It really helps us move things along, and we appreciate you sharing your testimony today. I will now turn to committee members to see if they have any questions for you, and I will begin with Representative Thorne.
Thank you, Mr. Chair. Thank you, Ms. Grant Whedon, for coming today and helping us understand this bill as it applies to you. in your son's case, was there an issue with his genitalia
No,
that you took him there for, or that was just a routine initial exam?
yeah, it was a routine physical. It was his well child visit that they get every year. And there was nothing wrong with his penis.
Okay. That was all I had. Thank you.
All
Thank
right,
you very
thanks.
much, Representative Thorne. Are there additional questions for Ms. Grant Whedon? Seeing none, again, I thank you very much for presenting your testimony to the committee today. We greatly
Thank
appreciate
you.
it. I would now ask our committee clerk to please move over Destiny Johnson as a panelist. And right now, that is the last person that I see in the attendee room who has indicated they want to speak in support of LD 1292, but I do not want to miss anyone. If you are here to testify in favor of the bill, please raise your electronic hand and I will call upon you. Ms. Johnson, welcome.
Hi.
To. Excuse me?
Oh.
Welcome to the Judiciary Committee, and as soon as you are comfortable, please begin your 3-minute testimony.
Good morning, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Destiny Johnson of Wyndham, and I'm in support of LD 1292 and LD 1510. Can you guys hear me okay?
Yes, you're coming across loud and clear.
Okay. LD 1292 would require parental consent for all medical procedures involving minors, prohibiting physical exams, surgical procedures, vaccine administration, and prescription drugs from being given without parent and guardian consent. Maine law currently allows minors to obtain some important healthcare services, including birth control prescriptions, abortion care, and testing and treatment for sexually transmitted infections and or HIV without notifying or getting permission from a parent or guardian. Unfortunately, I've been through this horrible experience with Planned Parenthood and my 17-year-old son. LD 1292 would require parental consent for vaccine administration. My son Jacob, who was only 13 at the time, received HPV-9 valent vaccine and the hepatitis A vaccine on 12/7/2016 again and again on June 27, 2017 without my parental consent. In fact, his medical record states no adult was present in the room. I'm not sure if you guys can see this. States it right there. My son did not know what he was consenting to, and at his age, he did not understand the risks and the benefits. This doctor should have had my son's records and his previous records to his adverse events to his vaccines. They should not had this appointment without contacting me, and they did not contact me at all. If this is the law, if this law is already in place, what's the ramifications of breaking this law? All medical procedures on minor children should only be given with parent and guardian consent. I urge you to vote in support of LD 1292 and LD 1510. Thank you for your time, and thank you, Senator Lisa Keim, for sponsoring this bill.
Thank you very much for your testimony, Ms. Johnson, and I note that it's been submitted in writing as well. The document that you showed to the committee, it was kind of hard to see. If you want to submit that through the portal so the committee has it, feel free to do that as well.
Okay, thank you.
You're very welcome. Are there questions from committee members who have, are there questions from committee members for Ms. Destiny Johnson? Representative Libby.
I am happy to defer to Senator Carney. I believe she has a question as well.
Okay. Senator Carney.
Thank you. I was raising my real hand, but I just wanted to let Ms. Johnson know that anything that is placed in the portal is publicly accessible. And so if you do intend to submit that document as an exhibit, you probably would want to cross out or obscure any personally identifying information.
Exactly, right.
Representative Libby.
Thank you, Mr. Chair, and thank you for noting that, Senator Carney. Thank you for being here today, Ms. Johnson. I'm trying to follow. Can you clarify the scenario in which your child was vaccinated without your consent? I'm not clear on how that could possibly happen.
So initially, I understood that he was going to this medical doctor for not annual physical exams. It was according to his father, and it was just for someone to talk to. And I never knew of this appointment at all until I received his medical records.
Thank you. So it was a scenario where someone else had taken him to the doctor for maybe a mental health visit. Is that?
Yeah, he was going there just to speak to someone, kind of like a counselor.
Thank you for clarifying that.
Thank you, Representative Libby. Representative Moriarty.
Thank you, Mr. Chair. So, Ms. Johnson, just so that we know the full story, did your son's father consent to this treatment? And to
He did not.
No?
No. It actually states on this record his father was in the parking lot, and no adult is present in the room.
No, understood. But did he consent to the vaccination or anything like that?
Not that I know of. No. I actually asked him about that, and he was not aware of that.
Okay, thank you.
He was aware he was in there for counseling.
Okay, thank you.
Thank you.
Thank you, Representative Moriarty. Did you have an additional question, Representative Libby?
I do. Thank you, Mr. Chair. Ms. Johnson, we heard from Senator Keim about the exceptions that she has included in her amendment to this bill that specifically speak to things like mental health treatment that minors can access. So it seems like your son seems to have hit in a gap, an existing gap in the law, where he actually went for one purpose, but then was treated for another. And so thank you for bringing that up and clarifying that. I think that is an important piece to note regarding the initial purpose of the visit and then what actually occurred. So were these appointments both for that mental health piece that he initially went?
Yes, the same doctor.
Okay, thank you so much.
And I'm still trying to digest it too. Thank you.
Thank you.
Thank you, Representative Libby. Are there additional questions for Ms. Johnson from committee members? Seeing none, thank you very much for presenting your testimony to the committee today. We greatly appreciate your time.
Thank you.
Thank you, Ms. Johnson. Okay, at this point, I'm a little confused. I see an Elizabeth Caruso as a panelist. I also see an Elizabeth Caruso as an attendee. And I know that there is an Elizabeth Caruso who registered to testify in support of LD 1292. So if the Elizabeth Caruso who is has been admitted as a panelist already could activate her microphone and video and begin your 3-minute testimony when you're comfortable. Ms. Caruso, can you hear us?
I can hear you. Can you hear me?
We can hear you. We cannot see you.
I do not have a video.
Okay.
For some reason, the button.
Are you still with us?
Oh, I see. Somehow I got here I am.
Okay. Welcome to the Judiciary Committee. And as soon as you are comfortable, please begin your 3-minute testimony.
Very good. Thank you very much, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Elizabeth Caruso and I live in Caratunk. I am testifying in support of LD 1292. And I respectfully request that you support this for parental rights and to protect Maine children. It is unimaginable that these parental right protections for our children would be needed to deliberately be stated in the state of Maine and the United States of America. However, unfortunately, these clear protections are necessary to be ingrained in law. This is not Germany, where children are seen as the property of the government, and yet there are states that have publicly stated they would forcibly remove children to an isolated location. Can you imagine your child being taken from your home? Can you imagine the fear and trauma your child would experience? Or about the shame and condemnation they would feel just for having a high temperature or exhibiting symptoms? Children want to be loved and cared for at all times, but especially when they're not feeling well. Every parent knows this, and there is nothing like the care and comfort that a parent and home provides. It is also horrific to think that any state or medical personnel would even consider physical examinations, surgical procedures, and vaccine or drug administrations to be performed on a minor without parental consent. Yet that is the overreach that our children need protection from. Every parent knows how nervous, scared, shy, intimidated, and even confused children are with strangers, in a strange environment, or in a sterile doctor's office or hospital. Children rarely speak up for themselves to strange adults or feel comfortable or confident advocating for themselves. Furthermore, children don't often, if at all, remember sensitivities, allergic reactions, or past health history to relay pertinent information to a healthcare provider. Parents are aware of these critical roles in advocating for and protecting their children. Even adults who are unwell due to illness have a difficult time advocating for themselves in a hospital, especially if they are not cognitive or alert. Even more so, our children and minors need a parent who knows them behaviorally, developmentally, historically, and physically to advocate on their behalf. Although LD 1292 lists parental rights in its text, this would be a law to protect our children's rights. Please let's fortify parental rights in the state of Maine so that our children are safe from such an atrocity. The safety of our children and the unity of the family is the crux of a healthy society. Please vote to pass LD 1292, and I thank you for your time and your service.
Thank you very much, Ms. Caruso. Are there questions from committee members for Ms. Caruso? Representative Libby.
Thank you, Mr. Chair. I actually don't have a question for Ms. Caruso. It's just a tech issue. Thank you for being here, Ms. Caruso. Mr. Chair, I cannot get access to the amendment. I can't find it, and I feel like it's very pertinent to hearing the bill, both the proponents and opponents. Is there a way that we could maybe be emailed the amendment? I don't know if it's just me having tech issues.
I will ask the analyst to email the amendment to the committee. It is available on the committee site. If you go to
I'm on the site and I can't, I don't know if it's just a glitch on my part or what.
I will ask the Sam, is that something you can send to the committee?
Yes, it was emailed yesterday afternoon, and I will email it again. I also have provided a link, a direct link to the posted amendment in the chat for both participants and panelists.
Thank you. I would appreciate an email. I'm on a second device that I don't have access to.
Sure thing.
And all that. Thank you.
Thank you, Sam, and thank you, Representative Libby. Representative Thorne.
Thank you. Thank you, Mr. Chair. Is it possible that Sam could maybe verbalize what the crux of the amendment changes verbally?
No.
It's pretty significant. It's a two-page amendment with quite a bit of new language. I don't think that would be possible. I mean, I would ask the analyst if he thinks that's a feasible thing to do, but.
Is it possible that he could maybe attempt to summarize the crux of it without reading the entire 2 pages?
I'm understanding that we can't do that at a public hearing. As the analyst indicated, the amendment was sent out to all committee members last night. A link has been posted in the chat to see it. But we will certainly be able to address those questions at the work session.
All right. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Newell.
Thank you, Mr. Chair. Good morning, Ms. Caruso. Thank you for being here and providing your testimony. I'm not sure if it's me, but have you had an opportunity to submit your written testimony?
I have, yes. And I received an email.
Okay, then it's me then. I'll continue to look for it. Thank you so much.
It has been submitted through the portal, Representative Newell.
Okay, I'll do a refresh. Thank you, Mr. Chair.
You're very welcome. Representative Thorne, did you have an additional question?
Residual, sorry.
Okay, not a problem. Representative Libby?
I am sorry. I am having the same tech issue as Representative Newell. I'm in the portal and I don't have her testimony. So I don't know if we're having tech issues or what. But
Have you tried to refresh it? Because
I have.
I was reading it.
Mr. Chair, is there a difference where this was scheduled for May 6th? Is there a difference between what's contained on the portal and on May 6th versus what's contained there for today? Is that the issue?
I'm looking at the portal from today, which I logged on to before the hearing, and I'm seeing the testimony. It was, looks like it was resubmitted at 9:18 this morning. But we will make sure everyone has access to the testimony at the conclusion of the public hearing.
Thank you.
Thank you, Representative Libby. Representative Evangelos?
Thank you, Mr. Chair. Sam, I just checked my email. Sam just sent the amendment again, folks, if you want to look at it.
Thank you, Representative Evangelos. Are there additional questions for Ms. Caruso? Seeing none, thank you very much for taking the time to present your testimony to our committee today. We greatly appreciate your input.
Thank you all.
That concludes the people that I have seen that have indicated they are signed up to testify in favor of LD 1292. But again, I don't want to miss anyone. If there's anyone in the attendee room who wishes to testify in support of the bill, please indicate by raising your electronic hand. And seeing none, I will now turn to persons who have registered to testify in opposition to the bill. And I have a similar problem to what occurred before. I have a Colby Wyatt in the attendee room who registered to testify in opposition, and I have a Colby Wyatt who is a panelist. Colby Wyatt, if you could activate your microphone and video, and welcome to the Judiciary Committee, and please begin your testimony when you're comfortable.
All right. You all hear me?
We can, and you're testifying in opposition. Do I have that correct?
Correct, yes. So my name is Colby Wyatt. I'm a pediatric pulmonologist at Barbara Bush Children's Hospital, and originally native of Burnham, Maine, and very happy to speak to you all today in my opposition to Bill LD 1292. I'm also very happy to see the Matthew Russ original over Senator Carney's shoulder. He was my roommate in high school and a wonderful person. I mean, in college and a wonderful person. Anyways, so my written testimony details my complete concerns with the legislation, including the effects on minor autonomy. But in the interest of time, I'll focus here on advanced directives and medically ineffective care. Initially, on reading this legislation, I was rather puzzled because I'm actively involved in end-of-life decisions as part of my practice. And I'm unaware of any instance where there was an end-of-life care that was withheld without the knowledge or consent of a parent. Additionally, I just discovered that state statute Title 22, Chapter 260 already limits the authority of a surrogate to withhold or withdraw life-saving treatment. When I was discussing this with the hospital, Maine Health also notified me that they are unaware of any issues that have arisen at a Maine Health hospital or any other care setting involving the withholding of life-sustaining treatment for minors without the knowledge and consent of a parent or guardian, which is the specific issue this bill is addressing, the language in this bill addresses. I think that's because it's simply not how we practice healthcare. Providers are already held to ethical and professional practices around these discussions and decisions. As part of my personal practice, I care for children with respiratory failure from neurologic disease and those who live on ventilators at home. Some of these children do have diagnoses that will shorten their lives significantly, including, unfortunately, some of them dying in childhood. When children have these diagnoses, it's the standard of care to have regular end-of-life discussions with their parents. It's my job and the job of my colleagues to understand what the parents' values are and what their wishes are for their child and their child's health care. I've spent countless hours advocating for parents' wishes and trying to obtain resources and interventions needed to help them attain what they consider to be the best quality of life for their child. When the child's nearing the end of their life, we typically begin by reviewing with the parents their preferences for care. We also then review all of the available interventions and medications. I typically start with those that are minimally invasive to those that are maximally invasive, with the potential benefit and harm of each intervention described to the parents. These choices aren't presented like menu items at a restaurant. There is a component of advocacy for the well-being of the child. Sometimes the maximally invasive option has no real clinical benefit from the child, and it's ethically important to prevent the suffering of the child due to ineffective medical interventions. This vow is also already expressed in a Maine statute, Title 18A, Article 5, which states clinicians cannot be forced to provide medically ineffective or medically inappropriate care, contrary to generally accepted healthcare standards. More importantly, though, it's counter to an oath I took when assuming the role of a physician to first do no harm. As a result of engaging parents in medical decision from an early, I'm sorry,
Dr. Wyatt,
yes,
your 3 minutes is up. If you could conclude in a sentence or two, please.
Absolutely. This legislation is unnecessary and redundant, and there are already avenues within our healthcare system to address physicians who operate outside the general standard of care and in the interests of parents and children. Thanks for the opportunity to testify. I'd be happy to answer any questions you might have.
Thank you very much, Dr. Wyatt. You indicated that you were originally from Burnham, but could you just provide your town?
Sorry, I live in Gorham, Maine now, and practice in Portland, Oakland, and Lewiston.
Thank you very much. I'll now turn it over to the committee members to see if they have any questions for you. Representative Moriarty.
Thank you, Mr. Chair. Dr. Wyatt, we're now getting into the heart of the matter, and I don't think in reading the bill and the amendment that this is designed to micromanage the physician-patient relationship. But let me ask you a very specific question about the withholding of treatment as it relates to the language now before us. In your experience, are you aware of physicians who, on their own, institute an order not to resuscitate, institute an order to withhold an artificial life-saving or life-sustaining procedure, or order the withholding of artificial nutrition and hydration for a minor without obtaining the consent or permission of the minor's parents?
The short answer is no. I've read the cases and I listened to the earlier testimony, and my heart breaks at hearing the true pain in the parents' voices of what they say they have experienced. But in my own practice, that's not how, in taking care of critically ill children for over a decade now, it's not how we practice medicine.
Right, thank you.
Does that conclude your question, Representative Moriarty?
It does. Thank you.
Thank you very much. Representative Libby.
Thank you so much, Mr. Chair. And thank you for being here today, Dr. Wyatt.
Thank you.
Having worked in SKU3 and SKU research for some time, I can appreciate the high quality of care that you provide. I do have a question regarding, fetal medical care. And we heard testimony regarding children that, yes, are not in Maine as far as the parents that spoke today, but regarding the children with trisomy 18 and where that care was regarded to be futile. I wonder if you could speak to that gray area where sometimes medical practitioners, might see that something looks futile, but there's a gray area there. And I think that is in part what this bill is trying to address. Certainly those children, things might have looked very futile, but in this case, in these cases, the parents persisted and their children are alive today. So I think that is in part what this bill is trying to address. And I wonder if you could speak to that lack of 100% certainty.
Yeah, it's hard for me to address those specific cases, not knowing what happened or the specific health cares of the child. Trisomy 18 can be a very devastating diagnosis and has different implications for different children that have it. In my own experience in working with children who have diagnoses that have documented and known to shorten their life, it's not a matter of saying this is going to shorten their life. You don't get this option. It's more of a matter of engaging with the parent on what they wish for their child's life, how much mechanical intervention they want, how much interference with sort of the existence in the surrounding environment from a medical support device they would like. Each level of intervention, starting with making sure the child has nutrition and comfort from a pure environmental standpoint, all the way up to mechanically supporting heart and lung, which we can do now with machines, has an impact on how the child interacts with the world and how parents interact with the child. And I don't know that everybody in the general community who don't work with those machines and who don't take care of people in the community on those machines understand that impact. So I see my role as using my experience and my knowledge around children who live on ventilators and who have ventilators in the home to help parents understand what that means for their children when that happens, and then let them make the decision. I do understand what your question about futile care, like if we are going to, the simplest example is CPR, for example. This happens more on the adult side than the pediatric side, which you would know working in SKU3. But when you start describing the results of CPR to people and the outcomes may not save the life of your loved one, and they may not end up the same person they were prior, as far as their interactions with the world prior to the performing a CPR. And then you leave that decision in the hands of the parent as to whether they want to try it or not. I will say that I always add in those discussions, if they decide to do something that I kind of feel would be less effective for the treatment of the child, I always ask them to establish a point where we could rediscuss whether that intervention is going to keep occurring.
Thank you. Follow up, if I may, Mr. Chair.
Yes, Representative Libby.
Thank you. Thank you, Dr. Wyatt. I appreciate your explanation there. I just would ask if, you've described a great standard of care where you lay out all the options and then are giving truly informed consent, and whether that involves follow-up later on and a reevaluation or not, it sounds like you do a great job of making sure that parents are well informed and then have all the tools they need to make the final decision. So I wonder, where would the issue be with simply making sure that's in statute, so that if someone doesn't have that same standard of care, it's very clear in the law that that is what is expected?
Oh, I understand. Well, I think it is already in statute. At least my reading of the Title 22, Chapter 260, which I was just was informed of yesterday. But one of the concerns I have, if you sort of create another level of statute like you're describing, is that there are instances where there are, I'm going to say, conflicts within families. I'll say parents that are more involved than other parents, or parents that are present when other parents aren't present. And my concern is that if there is an absent parent and we have all these in-depth conversations and we come up with something that would make the child most comfortable, be it a lot of intervention or no intervention, either direction, and then a parent comes on the scene who hasn't been involved in a while. In my reading of the statute, there's no sort of determination as to which parent would be, I guess, more responsible for sharing that decision making with the healthcare provider.
Thank you. That's very helpful, Dr. Wyatt. Mr. Chair, I do have one more question, but I'm happy to defer if someone else has a question while we have such a knowledgeable professional here with us. I do have one more question.
I do not see any other hands raised, so if you could ask your question now, I would appreciate that.
Thank you so much. Dr. Wyatt, we have talked a fair amount about end-of-life scenario, but that's not all that's contained in this bill. And so we heard from I believe it was Ms. Johnson, regarding her child who had gone in for mental health care, which is one of the exceptions that this bill would maintain, that of course minors can get psychological care as needed under the law, and this wouldn't change that. But this would address that issue that had occurred for her child, where they went in for one reason and then were vaccinated without the knowledge of either parent. So I wonder how you might prefer to see that loophole handled, if not by this bill.
I provide some vaccines in my clinic, but we don't provide a lot of vaccines because we're a specialty clinic. So we don't provide vaccines without parental consent at all. That's actually a non-starter. So even if there's somebody who, say, somebody gives permission for their grandparent to bring a child in for a visit, we don't, and there's not a specific consent for a flu vaccine, we will not give them a flu vaccine. So I don't know the specifics of this case, but I do know that we already are held to professional standards where we are not allowed to provide medicines without consent of the parent. Zoom visits like this meeting here have taken place of some of our clinic visits, and we've had patients come on to Zoom, teenage patients come on to Zoom without parents around, and we can't complete those visits because we simply don't have consent of the parents to complete those visits. So I think there are standards in place. I can't speak to directly whether those standards were violated in the case that we heard about, because I don't know the specifics about it, but that would not happen in our clinic.
Thank you. I appreciate that you are dedicated to making sure those standards are upheld.
Thank you, Representative Libby. Are there additional questions for Dr. Wyatt? Seeing none, thank you very much for your time and providing testimony to the committee today. We greatly appreciate your input.
Thank you.
I would now ask the committee clerk to please move over Laura Harper, who is registered to testify in opposition to LD 1292. That may take a minute. I will wait till I see her in the panelist room. And I do, Ms. Harper, when you are comfortable, please begin your 3-minute testimony, and welcome to the Judiciary Committee.
Thank you so much. I really appreciate it. Representative Harnett, Senator Carney, and honorable members of the Judiciary Committee, my name is Laura Harper. I'm a senior associate at Mooseridge Associates. I live in Hollowell. Today, I'm sharing with you testimony on behalf of my client, Maine Family Planning. These are the words of Evelyn Celtica, a women's health nurse practitioner and senior vice president of program services at Maine Family Planning. Maine Family Planning provides comprehensive sexual and reproductive health care to teens and adults at 18 locations statewide. And I'm here today to testify in opposition to LD 1292, which could have a chilling effect on minors' access to reproductive health care. Maine law currently empowers young people to take control of their sexual and reproductive health, allowing minors to obtain some important healthcare services, including birth control prescriptions, abortion care, and testing and treatment for sexually transmitted infections or HIV without notifying or getting permission from a parent or guardian. Pursuant to the statutory provision around family planning services for minors, physicians and nurse practitioners make confidential reproductive healthcare services available to teens in healthcare settings across the state, from pediatricians' offices to family planning clinics to emergency rooms treating survivors of sexual assault. Happily, many young people choose voluntarily to involve a safe adult in their sexual and reproductive healthcare decisions. All teens who come into a Maine Family Planning Health Center are counseled by an experienced medical professional about the benefit of involving a parent or guardian, and the majority of our teen patients are able to do so. But some are not, and it's those young people I'm most worried about, because those teens who can't talk to an adult about sexual and reproductive health care, they don't stop having sex in the face of parental consent requirements. They just stop getting the health care they need. In a 2019 survey of youth ages 14 to 24 published in the Journal of Pediatrics, we found youth may lie about their risk behaviors or not seek health care when concerned about confidentiality. So not only could a sweeping parental consent law endanger teens who face a risk of abuse or violence in their homes, but it also places them at risk for unintended pregnancy, untreated STIs, and unhealthy relationships. You have my written testimony, so I'm going to go off script here. I know I have limited time. I did have the opportunity to review the sponsor's amendment early this morning, and not as much time as I would have liked. We talked about not testifying against this bill this morning with my client. But because that sponsor's amendment is drafted so it's confusing at the end, at the final page where you look at that section on exemptions, I recognize that there are family planning and minors consent for medical services exempted there, but it appears like it could be only in emergency situations. And because of that confusion, we just felt so strongly, we wanted you to know our position that we would oppose that. Maybe that's not the sponsor's intent. So we are looking for that clarity, but in the face of not having that in time for this public hearing, we did want to testify strongly against the bill as amended.
Thank you very much, Ms. Harper. And we appreciate your bringing your testimony before the committee this morning. Are there questions from committee members for Ms. Harper? I will begin with Representative Thorne.
Thank you, Mr. Chair. Ms. Harper, I read the same thing under exceptions. And it pretty much says an individual licensed under this chapter may perform a physical examination or surgical procedure on or prescribe prescription medication to a minor without the permission of the minor's parent or guardian.
Yeah,
That
it was
seems pretty clear to me though, doesn't it?
I appreciate that. It was the section at the end on exceptions, number 3.
That was the one I just read.
Yeah, so the exemptions that include family planning, like Title 22, Section 1597A. So those are, it's unclear to me if those are subgrouped underneath the piece about the emergency needing to exist for those exemptions to occur. And so that's where I couldn't tell if the sponsor was saying, if there's an emergency that exists, then these can be exempted from here. So that there was just that confusion around clarity that really gives us a lot of heartburn on this bill. So there's an A, but then there's another A, a B, a C, a D. Are those, is that second A a subgroup underneath the first A? So I hope I'm being clear. I apologize.
It seems to me that they're listing it as if the individual license under this chapter determines that an emergency exists during the examination, procedure, or prescription, and it includes those items that you mentioned. To me, that's the way I read it. Maybe
so that would give us great concern. We would not want it to be only in emergency situations that our practitioners can provide that confidential care when it comes to family planning services with minors who choose not to involve a trusted adult or a guardian.
So the terminology behind emergency that is okay. Thank you.
Thank you, Representative Thorne. Representative Libby.
Thank you, Mr. Chair. Although I do see Sam's hand up, I'm sure that he would have some clarification for us. Thank you for being here today, Ms. Harper. If instead of A and then followed by A, B, C, D, if that section was A, B, C, D, E, would that clear up the concern and make it clear that it is all 5 are exemptions rather than family planning being included as an emergency?
Yeah, I think that would provide much more clarity and we'd be able to reevaluate our opposition to the bill. I don't feel comfortable telling you, oh, we'd be fine right now here. I'd want to talk to my client and go through the new language with them. But that was the biggest red flag for us when we were quickly reviewing the sponsor's amendment this morning.
Thank you very much. Mr. Chair, could we hear from the analyst on this? I wonder if he could give some clarification.
I was about to do that. I wanted committee members to have the opportunity to ask their questions before turning to the analyst. Thank you, Representative Libby. Sam, did you want to provide some clarity about the amendment that was drafted?
Yes, sure. My apologies to the committee. That was an autocorrect numbering error, and I am correcting it right now and sending out a corrected copy to the committee. It should read A, B, C, D, E. So it's not it's that first A is not a header with the rest falling under it. They should all fall in line as separate exceptions. And I will make that correction and send it to the committee and post that right now.
Thank you. And that would be a very important issue for the committee to address at the upcoming work session. Thank you for pointing that out, Representative Libby and Ms. Harper. Representative Sheehan.
Thanks, Mr. Chair. I just wanted to ask for a little further clarification from our analyst, Mr. Senift. So the error in drafting would mean that providers can still offer confidential services in situations that are not emergencies.
Correct, Representative.
So if providers are able to provide all of these services to minors who seek them without their parents' permission, I'm not entirely sure what the bill is for. If minors can freely seek advice from medical professionals in family planning, reproductive health, gender affirming care, I'm not really sure what the goal of the bill is, but that's probably not really a question for you. So
right, Representative Sheehan, I agree that that's not an appropriate question for the analysts, but certainly might be appropriate at a work session to have the sponsor address that as well. Are there additional questions from committee members for Ms. Harper? Seeing none, again, thank you very much for your time and testimony this morning. We greatly appreciate your input.
Thank you.
I would ask the committee clerk, who reads my mind, to, I will now welcome Dan Moran, who registered to testify in opposition to LD 1292. Mr. Moran, nice to see you again. Please begin your 3-minute testimony as soon as you feel comfortable.
Great, thank you. My name is Dan Moran, Director of Communications and Government Affairs for the Maine Medical Association. Thank you, Representative Harnett. Hello, Senator Carney and members of the committee. The Maine Medical Association is located in Manchester. I'm coming to you from Gorham. The MMA is the state's largest professional physician organization, representing more than 4,300 physicians, residents, and medical students across all clinical specialties, organizations, and practice settings. We are providing testimony in opposition to LD 1292. You know, it's interesting. I've been doing this a long time, representing physicians and healthcare organizations, and it's heartbreaking to hear some of these stories. I'm a parent of 3 kids, but at the same time, regardless of what bill is before this legislature or any other committee, HIPAA prevents medical providers, physicians included, from publicly disclosing any information about medical care provided or a patient's condition without express written permission. So unfortunately, our members can never provide a detailed public response to any allegations or processes of care. So without seeing that, or without knowing the specifics of any case here or another state, our legislative committee and our board of directors finds it hard to analyze legislation. So we have to look at it as a whole. And much like you heard from Dr. Wyatt, the physicians that I talk to among our leadership look at bills like this and see concerns, because we have state medical boards that treat allegations of misconduct and deviation from accepted standards of care or deviation from the law or rules. They take it very seriously and place a high priority on investigating complaints. We commonly monitor licensing boards, and let me tell you, the list is pretty long about going through complaints, and the investigations are pretty thorough. For a minor patient, consent for treatment pretty much must be obtained from a parent or guardian by law, with the limited exceptions that you've heard today. I looked at the amendment also. I had the same concerns that Ms. Harper expressed. I'd have to take the amendment back to our legislative committee and our board of directors to take a look at it. We did email, I did email the bill sponsor at the end of April to ask for specifics about where the bill originated from and some of the questions we had, but didn't hear back. So it was tough to draft testimony without knowing the context at where the bill was coming from. I'd be happy to take any questions back to our physician leaders on this bill, but as of now, we stand on our written testimony opposed until we get clarification and feedback from our members on the amendment and the specifics of the bill.
Thank you, Mr. Moore, and you made it right under the 3-minute wire. Always appreciated. You mentioned that today you were coming from Gorham. Is that your residence?
Yes, sir.
Thank you. I will now turn it to the committee to see if there are members of the committee that have questions for you about your testimony. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Moore. And I have 2 quick questions. One is there a reason that there should not be a law that would supersede and ensure that healthcare policies are followed?
You know, we're going to be providing, thanks for the question, by the way. I grew up right across the river in Lewiston, so go Lewiston Auburn. Go Lewiston better, though. Just kidding.
I don't know.
We're testifying on the follow-up bill to 1510, and in discussing this bill and the other bill, our physician leaders don't see any reason to change the current consent laws as they're written, unless we're provided with clear reasons why and clear legislation why. You know, I heard about Simon's Law, and coincidentally, I actually was the director of communications for the Kansas Medical Society, Kansas physicians, while my wife served in the military in Kansas. And so I did take a look at Simon's Law, and that law is very clear and specific to consent regarding one parent or guardian being informed orally in writing of any planned DNR. So this bill is much more comprehensive than Simon's Law. So if it were something like that, we could take it back, because I believe the physician community in Kansas supported Simon's Law because it was very clear and it was very confined to one specific area.
Thank you very much. And my final question was just a simple yes or no question. And it's, would you agree that parents should have the final say regarding their minor child's medical decisions?
You know, with all due respect, Representative Libby, I have 3 daughters. A yes or no answer. You know, it's funny. I asked them to give me yes or no answers, and it's complicated for them to do it too, because there's a lot of gray in between. So I cannot answer yes or no, because I can't even answer yes or no if my own physician, my own kid's physician, would ask me that question. So I think in certain cases, as outlined in law, physicians are in the best position to determine whether medical treatment is appropriate and whether there is a clear danger at whether or not to inform parents of a particular procedure. So thanks for the question, though.
Thank you.
Thank you very much, Representative Libby. Thank you for your response. Mr. Moore and Senator Carney.
Thank you very much, Chair, and welcome, Mr. Moran. I just wanted to ask you if you could provide a little bit more information about the circumstances of Simon's Law. Is it well, yeah, could you just tell us a little bit more about that? I was confused by your reference to it.
So the law, and I do have quite a few resources at my disposal in Kansas due to previous political and personal relationships, so I can find out as much information as you want. Under Simon's Law, at least one parent or guardian must be informed orally and in writing of a planned DNR order. And this case specifically touched on an effort must be made to contact the other parent too, if the parent is reasonably available and has custodial or visitation rights. If the parent refuses consent, no DNR order can be instituted. If the parents disagree about DNR, they can go to district court. So from my understanding, and if Simon's mom shows up today and has a different perspective from what I read, which she should because she was involved directly, then I'll defer to her. But that law was specifically had to do with informing at least one parent about a DNR or a planned DNR and the process to go about in doing that. And if parents disagree, the process they can go about through the legal remedies to address DNR situations. I can
Thank
provide
you.
you a copy of the actual law and the bill and all the testimony if you want.
Actually, could we please have a copy of the law, but I don't think we need all of the testimony, just what was enacted, please. Thank you.
Absolutely. I'm still just as familiar with researching their laws as I am ours, even though I'm from here. So thank you.
Thank you, Senator Carney, and thank you for your response, Mr. Moran. Are there additional questions for Mr. Moran from committee members? Seeing none, again, thank you very much for your time today and for presenting your testimony to the committee. We greatly appreciate your input.
Thank you, sir.
I do note that although not registered to testify today, that Jeff Austin was in the attendee room and he had registered to testify in opposition to the bill when it was originally scheduled. Mr. Austin, did you want to provide testimony today on LD 1292?
Yes, I would appreciate that, Representative Harnett.
Thank you. As soon as you're comfortable, please begin your 3-minute testimony.
Senator Carney, Representative Hartnett, members of the committee, my name is Jeff Austin. I'm here on behalf of the Maine Hospital Association. I will try to be quick and brief. I saw the amendment for the first time when it was posted in the chat room, so I am just digesting it. But let me try to address what I think are the 3 issues in the bill. Section 1, at the end of the day, based upon the amendment, it looks like it is only regulating the behavior of the department and the department's authority to remove children from homes and place them in quarantine. I don't think that implicates us. If it does deal with hospital ability to place patients in our custody, if you will, in isolation, we would have a concern because we do that all the time. But if it's purely about the department and removing kids and putting them in quarantine, I would suggest you reach out to the department specifically and get their reaction to that, but it wouldn't be us. Section 2 has potentially morphed a great deal in that it appeared to originally be about the circumstances for minor consent. And based on the amendment, it looks like they're trying to, Senator Kime's trying to preserve the minor's ability to consent. I'm not sure she's captured every existing provision. For example, I don't see 22-18-23 on her list, which is a minor consent provision. So, but her testimony appeared to be that she's trying to preserve the abilities for minors to consent, at least as it exists today. And instead, what's happened is the amendment has sort of morphed more into a standards of care discussion in these very difficult situations. And I think we have a concern, to address Representative Libby's question, about placing in statute these very difficult situations. That's not to say that there isn't a state role. There is, but we think it is through the boards of licensure and the medical expertise they possess to establish standards of care, as opposed to the legislature's expertise to establish standards of care. That's really what you're getting into now. So having a regime is appropriate, but that is why you created the board of licensure and you created a board of experts to have these conversations. I have no idea what treatment is futile means in a statutory regime. I don't know what medically inappropriate means in a statutory regime. These are the kinds of standards that are really clinical, as opposed to more traditional, what was in the original bill, statutory consent. Can the child consent, yes or no, or does the parent consent? So,
Mr. Austin, that brings you to the end of the 3-minute testimony. If you could just wrap up.
Yeah, I will try to digest the amendment further, and I'm happy to take any questions.
Thank you very much, Mr. Austin, for your testimony today. Representative Moriarty.
Thank you, Mr. Chair. Mr. Austin, I'm so glad you mentioned Section 1, because back at the beginning of the hearing, I'd raised a question about that, and it had since slipped my mind. Section 1, I agree with you, appears to pertain only to cases in which the DHHS is involved, and there may be grounds for isolation or something like that due to an infection. So when a minor becomes severely infected or contagious at a hospital, and the hospital determines that the minor ought to be in seclusion somewhere, is the DHHS involved at all in that decision?
No, unless they're sort of the surrogate decision maker, I don't
No,
think.
okay, sorry. Assume they're not involved in the familial relationship whatsoever.
No, if you get diagnosed with a MRSA infection, we'll put you in an isolation room, which has walls instead of curtains and can be greater cleansing capabilities and all the rest of it. So, or you have Ebola, we're going to put you in isolation. I think sometimes under this, there might be confusion. I'm looking at the amendment over here, sorry. There may be confusion sometimes among the public. If you test positive for COVID, you'll get a call from your practitioner saying, under CDC guidelines, you got to stay quarantined for the next 10 days. That's not technically us, the doctor, putting you in quarantine. It's the state. We're the messenger, though, for the CDC guidance about quarantine. So there may be some confusion as to who is placing you in quarantine. We're giving you the test results, and we're conveying to you the CDC's guidance and rules about quarantine, but that's not actually our authority to place you in quarantine at home.
Okay, but to be clear, if a decision is made by the hospital that quarantining is required, you don't have to go to the department first to get permission. Is that right?
Or an inpatient? No.
Okay, thank you.
Thank you, Representative Moriarty. Thank you for your response, Mr. Austin. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Austin. I appreciate that you zipped right through the amendment and were able to speak to that. I wonder if you heard earlier testimony and if you might be able to speak to that case where the child seems to have fallen through the cracks in the law, where a practitioner gave without parental consent vaccines when the child was there for mental health care, which is of course an exemption. And that, as you said, that exemption is intended to be maintained by the sponsor of the bill. So if you could speak to that and how you would see a way to kind of fix that gray area where this child slipped through the cracks.
I did not hear that testimony the same as you did, Representative Libby. I'm not a clinician. I will yield to clinicians, but I understand the HPV vaccine to be a precaution that is advised for sexually active people to prevent disease. And I think that might fall squarely within Section 1908 that the senator seeks to preserve. And I put the table in my written testimony. 1908 is for contraceptive supplies, contraceptive procedures, and related counseling, the prevention and treatment of infertility, appropriate prenatal and obstetric care, the prevention or treatment of sexually transmitted infections, and other related services. I thought he was going, I mean, none of us know the facts of the case, but I thought I heard the young man was getting counseling for sexual health, that he may or may not have been. I don't want to speculate on a particular kid. I just thought that that's what I had heard, that it was related to sexual activity. And in the course of that counseling, they may have discussed the risks and benefits of that vaccine. Whether the clinician went through all the appropriate clinical steps pre-clearing a child for vaccine safety, I don't know. I have no idea. But I would ask a clinician whether HPV vaccine falls squarely within some of these sexual health specific consent exceptions that I believe Senator Kine was seeking to preserve. I can't speak more intelligently than I just did.
Sure, I appreciate that. And actually I think you bring up a very good question. So we'll certainly have to digest that in the work session. I would note, I'm looking at the testimony again, the child was 13 at the time and a parent was there. I suspect that as she had said, it clarified that it was for mental health and not sexual health, that I think that falls squarely outside the realm, but that is also an exception, the mental health piece. So I guess that's a moot point, or not. It still brings up the same question. If you have a 13-year-old who is going for mental health care and gets treatment for something that is completely outside of that, how could we fix that outside of this bill?
My suggestion is, I would be careful about legislating on something where we have facts in such confusing states, because I mean, normally a mental health clinician is not licensed to order an HPV vaccine. So there's a wrinkle here that I don't understand. I have a feeling it was someone licensed to provide that vaccination. If not, then you have plenty of existing regulatory regimes to go after somebody for writing a prescription and administering a vaccine that they're not licensed to provide. But again, we're getting so down this road of one particular case where none of us really has the facts.
Well, I appreciate your time and attention to the questions, Mr.
Thank you,
Austin.
sorry. Can't
Thank you,
provide more.
Are there additional questions for Mr. Austin? Seeing none, thank you very much for your time and testimony today. That concludes the list of persons that I have who registered to testify in opposition to LD 1292. I will check to see if there are other persons in the attendee room who wish to testify in opposition to LD 1292, and seeing none, I would then ask if there are any persons in the attendee room who wish to testify neither for nor against LD 1292 to please raise your electronic hand. And again, seeing none, having heard from all persons present who wished to offer testimony today, I will now close the public hearing on LD 1292. Again, thanking the bill sponsor for bringing the bill forward and for all those persons who participated by providing testimony. We will now turn to our second public hearing, which is on LD 1510, an act concerning informed consent of minors' authority to release healthcare information, again presented by our committee colleague, Senator Keim. Senator Keim, whenever you're ready, please begin your presentation of LD 1510.
Sorry, this is the craziest morning as I have another bill up in education. So I'm trying to do this on another device, which is my phone. And can you see me and hear me?
Yes, we can.
Okay. I'm going to try to get through this. I have so much testimony sitting in front of me trying to make this happen. My apologies to everyone, but this is a crazy morning. Okay. Bear with me one moment. I just came out of cyberspace on education, which is supposed to have my bill up also right now. Okay. Good morning, Senator Carney, Representative Harnett, and esteemed colleagues of the Judiciary Committee. Thank you for allowing me to introduce LD 1510, an act concerning informed consent of minors' authority to release healthcare information. I am still Lisa Keim of Dixfield, and I'm honored to represent the citizens of Senate District 18. The impetus for this legislation stems from a conversation I had with a constituent, which then branched into many different parents telling me that they've experienced roughly the same scenario. My constituent was told by her child's healthcare provider when her daughter reached the age of 12 that she would no longer have access to her daughter's online medical records. This mother lost easy and immediate access to her daughter's medical records, including lab work, any diagnoses concerning health issues, billing, etc. Her allowed access to her own daughter's medical information was only through a request made at the doctor's office, to which they would respond by providing mailed copies of records, which, as you know, could be a significant delay, more significant these days. Before the age of 12, a parent can log in online and have full access to their child's medical records. My constituent inquired if there was a waiver that her daughter could sign allowing her access, and she was told that there was not. This is problematic for a number of reasons. Parents need access to their children's medical records so they can work to get them the care they need. Should results from a procedure come back abnormal, time is of the essence to seek proper treatment, second opinions, or alternative care. Having to receive results in the mail can seriously delay care. Attached to my testimony is a copy of a consent form from Maine Health. And from that, you can see that a minor may not give full proxy access to their parent after they reach the age of 12. According to the policy in this form, I could not give my mother, me, proxy access to my health records, but I could give proxy to my 19-year-old daughter. But my 19-year-old daughter, it would seem under no circumstances, could give me access. A healthcare provider has no right to make proxy decisions about my family dynamics over and above what my child and I decide what is right for us. Maine Health's policy, along with others in this state, seriously oversteps their authority, taking on a role of authority which supersedes that of patients. I understand the current system has been shaped by a desire to protect minors who are in unsafe or dysfunctional family situations. However, negatively impacting the normal and healthy family functions of caring parents is not an acceptable solution. It is always in the best interest of the state to foster laws and policies that preserve the integrity of the family unit and the lawful rights of caring parents. Timely access to records can alter the health outcomes of children. I ask the committee to consider parents' rights and work to find a solution that takes more accurate consideration for all Maine families. And I thank you for your time and consideration.
Thank you very
Happy
much.
to take any questions.
Thank you very much, Senator Keim, for bringing this bill forward this morning. Are there questions from committee members for the bill sponsor, Senator Keim? Seeing none, again, thank you very much for Representative Libby.
Thank you, Mr. Chair, and thank you, Senator Keim. I guess my question is around where the law is now. I'm not clear on, is this in statute that at 12 a child would have autonomy medically and their parent would not have access, or is this provider by provider? Can you just clarify that for me, please?
From what I've heard from constituents, it varies provider to provider, and but it seems that in essence, they're all erring on the side of ensuring that parents are locked out of full access to records, even if the child were to, and the parents had decided they wanted to go ahead and have that access and have that communication be open and free.
So follow up, Mr. Chair.
Yes, Representative Libby.
So, and you're saying this is in, because I understand there's the exemptions. We have the mental health and the family planning and all of that, but you're saying this extends beyond that to areas of just their basic health as soon as they hit 12 for some of these providers.
Right, and just because a child has the right to make their own decisions on some of their health care doesn't necessarily mean that that child wouldn't want their parent to have access to that information. I mean, I think that's where the problem lies, is that healthcare providers are assuming that because a child then becomes of the age that they can make these decisions for themselves, that then the parent shouldn't know about it. And that's really interjecting themselves into a family dynamic and situation that they have no right to block that access. And that's what they're doing. Their policies are blocking access. And I realize we've had so many issues with IT. My apologies about the other amendment not being online. It should have been, but I don't know if the chart that I had submitted with my testimony is available and showing to others. But I mean, you can see there that the proxy access doesn't even really make sense. I mean, it doesn't make sense for my 19-year-old not to be able to give me access if she wants to, or even my 13-year-old. that would be up to us to make that decision. And there just needs to be the ability for families to make that known, and that healthcare providers can't step in and make that decision over and above them.
Thank you very much.
Thank you, Representative Libby. Are there additional questions for the bill sponsor? This time I'm going to wait another second. Seeing none. Thank you very much, Senator Keim, for bringing the bill forward. I will now turn to...
And if I could just make one other comment, I'm sorry about how I seem to be going in and out and doing all this. As you can understand, I'm trying to balance the different committees. So my apologies to everyone that's here.
We understand until we master by location. That's the best we can do.
Thank you.
Thank you, Senator Keim. I will now turn to those persons who have registered to testify in favor. And I would ask of 1510, I would ask the committee clerk to please move over Ann Sarbanis as a panelist. And again, she has read my mind. Ms. Sarbanis, as soon as you are ready, please unmute your microphone, activate your video, and begin your 3-minute testimony. And welcome back to the Judiciary Committee. Ms. Sarbanis, are you able to unmute your microphone? Okay, it seems that Ms. Sarbanis might be having some technical difficulties. So at this point, I would ask the committee clerk to move over Jennifer White, who had signed up to testify if Ms. Wright is in the attendee room. Ms. White, as soon as you are comfortable, please unmute your microphone, activate your video, and welcome to Judiciary Committee, and please begin your 3-minute testimony.
Hi, members of the Judiciary Committee. My name is Jennifer White, and I live in Gray, Maine with my husband and 13-year-old daughter. I'm asking that you will vote in favor of LD 1510, an act concerning informed consent of minors' authority to release healthcare information. When my daughter was 11 years of age, I was told by a staff person at her pediatrician's office that at the age of 12, I would no longer have access to her medical records online. I was told that my daughter would need to sign a waiver for me to be able to access her medical records online. Excuse me. A little over a year later, in 2020, when she was 13, during her office visit for her annual physical, she asked for a waiver to sign so that I, as her mother, could have immediate access to her online medical records, her lab results, and billing. We were then told that no waiver exists for her to sign and that I could still have access to her records, but I would have to call and order them and have them sent by mail, which creates a delay. When we pushed the issue, we were told that this measure is in place because some kids at age 12 and above live in households that may be unsafe for them to disclose their medical records immediately to their parents. I think this rule is unfair and does not represent the majorities of families who are functional and caring. This rule presents issues for most families. For instance, after this appointment, my daughter had to have important blood work done because of a diagnosis of a serious health issue. After taking her to get her blood drawn, we waited patiently for the results. I was unable to access the results through the online portal because of her age. We waited for weeks and finally called the pediatrician's office to find out why we did not have the results yet. The pediatrician's office could not give me the test results over the phone, but said that I would have to call the number for medical records and ask them to mail me a copy. After jumping through hoops, we received the blood test results in the mail about a month after they were actually done. And only because I initiated the phone calls and requests. Her test results showed deficiencies that were alarming and should have been reported to us immediately. It required us to seek immediate medical advice and attention from a specialist. No parent or child should ever have to wait to receive medical test results, especially when a secure online platform is available and has been used by the parent with a medical facility before. Parents should have immediate access to their children's medical history, diagnosis, lab tests, and billing. Right now, when your child turns 12 years of age, your ability to immediately access those records is delayed and limited. Most parents are good parents that are trying to provide the best medical help and support for their children. Parents are also the best advocates for their children. They want to make the best medical decisions they can for their children and not
Ms. White?
allowing them.
Ms. White, I'm sorry to interrupt, but your 3 minutes has run out. If you could just wrap up your testimony, please.
Sure. They want to make the best medical decisions they can for their children, and not allowing them to have online access to critical medical records is working against that. My daughter, it could have been a very serious situation. And I'm asking that you would vote ought to pass on this important bill.
Thank you very much, Ms. White, for providing testimony to the committee this morning. I'm now going to ask committee members if they have any questions about your testimony. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Ms. White. My question is, I'm really confused by this disconnect. So your daughter needed immediate medical advice and attention, and when you went and sought that out, were you allowed to advocate on behalf of your child to get that care?
Yeah, so basically, my daughter had a diagnosis last year, and one that affects her lifelong, at least for now. And so I took her in for her annual exam, and they ordered blood work so that they could do a little more investigating into the diagnosis that was given by an outside professional. And so basically, I was with her at the appointment. I'm not sure exactly what your question is. You might want to.
Yeah, let me clarify. So when you finally did, a month later, get those results and go to have your daughter treated, you could be at the visit, you could advocate for her care, you could do all those things, but you weren't allowed to have access to the information prior. That just is such a disconnect to me. So once you then had the information and finally had access to it, you are allowed to then advocate for her to get the care. You're just not, in this scenario, entitled to have all of the pieces of information.
Yeah, it's just very strange to me. Yes, like she had blood work done. The lab results were not given to me. I was not able to access them online. I called the doctor's office. There was some kind of a disconnect there. They didn't have access to them and said I would have to call and order them, the results. So there was this long delay, and I knew they were busy, and I was trying to think, well, maybe they came back normal, and that's why I was waiting a couple weeks and not hearing anything, but I should have still heard something. And so I had to order them and wait, and it was a month before I actually had those results when I should have had them within days.
So can I ask one follow-up, Mr. Chair?
Yes, you may.
Thank you. So if you are not allowed to access online, was your child, at least, like, was she given an online access and able to access her own records?
I really can't answer that. I don't really know the answer to that. She doesn't have an online login or anything. I did speak with the doctor's office at her appointment because she wanted to sign a waiver. We were told prior to that there was a waiver she could sign. And so we asked for that, and we did speak to somebody, 2 different people at the doctor's office that basically said that the medical organization had discussed this. They were trying to figure out how to handle these kinds of situations, and that they didn't have a waiver for minors to sign. They didn't have, like, my 12-year-old couldn't sign to give me permission to have immediate online access to her records, which, as a parent paying that bill, which a lot of these bills we pay out of pocket, I think I deserve the right to know what I'm paying for, number one, and I should have access to know exactly what is going on with my child when she has blood test results and has a diagnosis that needs medical attention.
Thank you.
Thank you, Representative Libby, and thank you for your response, Ms. White. Are there additional questions from committee members? Seeing none, thank you very much for providing your testimony to the Judiciary Committee today. We very much welcome your input.
Thank you.
I am going to try to see, it might be that Ms. Surbanis is no longer here, but her link may have remained. But Ms. Surbanis, if you can hear me and wish to provide testimony on LD 1510, I know that you did mention your support of it in your earlier testimony. Please unmute your microphone and activate your video so that you can provide additional testimony if you desire. And again, seeing no response, and I will try again, I would ask if there's anyone in the attendee room who wishes to speak in support of LD 1510 to please raise your electronic hand so that you can be moved over as a panelist. And seeing none, I will now turn to those persons who registered to testify in opposition to LD 1510, and I would ask the committee clerk to move over Daniel Negrin, followed by Dan Moran. And Mr. Negrin, whenever you are ready, you've unmuted your microphone and activated your video. Welcome to the Judiciary Committee, and please begin your 3-minute testimony.
Thank you. Senator Carney, Representative Harnett, and members of the committee. I'm Dr. Daniel Nygren, the Chief Information Officer at Maine Health. I was previously the CIO at Boston Children's Hospital, where I also practiced clinically as a pediatric endocrinologist for 25 years. Boston Children's was one of the first in the country to provide teens with electronic access to their medical records. So this topic of parental access is one that I've been involved with for many years. Let me begin by saying that Maine Health provides parents with access to their child's medical information today, just as we did before we adopted our electronic portal via paper records and in person or over the phone. This bill isn't about access to legal medical information. It's about access to a minor's information through these recently adopted portals. Yet the consequences of passing this bill could have significant clinical implications for minors with legally protected healthcare needs. Our concerns with the bill are, number one, electronic health records don't currently have the ability to separate out all legally protected confidential components of the visit, including family planning and behavioral health, from non-confidential ones. And two, the legislation states that any authorization of a minor to share medical records would result in the release of the entire medical record electronically, including those provisions that are legally protected because they're sensitive in nature. So a minor might perceive that they're only giving their parent access to information relating to a recent orthopedic injury, when in fact, they've also inadvertently provided their parent with sensitive information, such as they've started birth control or that they struggle with drinking. Furthermore, the simple act of the teen not giving their consent, especially in the presence of a parent, could be harmful to that relationship as well, causing tension and distrust between them. Confidentiality for an adolescent is a core part of the successful partnership between the provider and the adolescent. When a provider meets alone with the teen, they ask about dating, substance use, mental health. When confidentiality of these discussions are afforded to the patient, data shows that the teenager is more likely to share important health-related information and seek answers to questions about their health. More importantly, some adolescents will only seek healthcare for such things if they are afforded such privacy. Confidentiality isn't always requested or needed by all patients, and providers currently have the ability to break that confidentiality if a minor is making decisions that are truly harmful for them. Parents play a critical role as a partner in their child's health, and providers encourage their adolescent patients to include their parents in health decisions. As with the visit itself, the sensitive parts of the medical record are intermixed with the rest of the documentation and aren't easily removed from a record. When we provide paper records to parents, we're able to redact those legally protected information before providing it to the parent.
Mr. Nygren, I apologize for interrupting, but we do have a 3-minute clock, so if you could wrap up your testimony in one sentence.
Just a few more sentences. So currently the technology isn't able to separate out those sensitive parts of the record from those that are not. It's a national problem that's recognized by the healthcare product vendors, medical record vendors. So once technology catches up with the laws,
thank you, Dr.
That access.
Thank you, Mr. Nygren. And you will have an opportunity to respond to questions from committee members if they have them, but I apologize for mispronouncing your last name.
That's okay.
Get it right the next time. I will now turn to committee members to see if they have questions for you, and I will begin with Representative Thorne.
Thank you, Mr. Chair. Welcome, Dr. Nygren.
Thank you.
I learned so much on this committee. Yeah, and it just shows how out of touch I am. Nowhere did I even fathom that a child and a doctor would be able to withhold information from a parent. I thought parents had total access to all their children's medical information, so I learned something today. So to clarify on that point, you're saying, is there any provision currently where me as a parent can come to you and say, here's my child, here we are, anything that you're going to release to the child, you can release to me, and here's my child's consent? It seems like we're upside downing on this, that a 12-year-old has to give their parent consent. But is there a provision to do that currently?
All with, except for the legally protected components of the record. And, there are very clear guidelines about what those are around, family planning types of issues and so on. This bill is really about the electronic provision of this data. And that's where the challenge is. And the challenge is that the technology that we have available to us in these electronic health records and the portals that we use to allow access to that data don't allow us to distinguish the legally protected confidential pieces of the record from those that are not, and to share those not protected pieces with the parent. As soon as we get the technology available from the vendors to be able to do this, we'll do it right away. We have no concern with doing that. And in fact, that would just be mimicking the manual process that we use today, which is to share that data. But if there is any of that legally protected confidential data in the child's record, it's redacted manually before it's given to the family.
So there's no way currently, if the child says, I want my parent to have total access to everything about me medically, there's no way to do that right now.
To be very frank, I don't know if there's any sort of legal provision to do that in a manual way. I don't believe so. I believe it's up to the patient to request it on their own, and then if they desire, they can share it with their parent.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Dr. Nygren. I have a couple questions for you. One is, we just heard a pretty compelling example from Ms. White about the inability of both her and her daughter to access some pretty critical information for it sounds like a month regarding her daughter's care. And I actually received a message from Ms. White that was via Maine Medical Partners, Maine Health, that they ran into this difficulty. So I wonder if you could explain to me the disconnect and how that could occur, that we have confidentiality trumping quality of care, so that crucial care is delayed for over a month because of these policies, and how parents should be directed to access their child's information if it can't be given electronically and it can't be given over the phone. How are parents to access that? Do they need to come in and have an in-person visit with the parent and the child to get results of lab tests? As a nurse, I've certainly never heard of someone having to do that, but I wonder if you could clarify how, without this law being passed, parents and their children might be able to access their own medical records to rectify this situation.
Sure. First, again, to state it up front, Representative, our goal is to do this, and we will as soon as the electronic health record vendors make the technology available that allows us to protect what is legally confidential from being disclosed to the parent. So we will do it immediately as soon as we've got that opportunity. For this particular case, it sounds like there was just a poor communication between the patient's provider and the patient and her mother. And I think that I don't have any insights to that. I can't explain it. What I would have recommended to her is that she could have simply just reached out to her provider as the weeks tick by to inquire about the results of the test to find out what those were and whether there was any follow-up that was necessary. But I think with respect to this bill, the challenge is that if it were to be enacted, we would be in a situation where we would be forced essentially to disclose information that we've got a legal obligation to not disclose. And that's going to have significant impacts on the care that we provide, especially to some of these teen patients who are entrusting us with some confidential information that, were it to be disclosed to their parents, would be detrimental to them. And so we would be in a tough spot is the bottom line.
So follow up, Mr. Chair.
Yes, Representative Libby.
Thank you. I appreciate that as far as Ms. White needing to follow up. I will tell you that I actually had a startlingly similar scenario reported to me by someone in a very different part of the state. So I am curious. I'm going to follow up and see if that was Maine Health or a different provider. But my follow-up question would be, I just want to clarify. So you're telling me that technology has not advanced to the point that it would be possible to simply separate those parts of the record that are confidential from now. We don't have the technology to date to do that. And if we passed a law saying that you had to provide these records, that technology simply has not advanced to that state, and that is an impossible scenario.
Currently, that's correct.
Okay,
yeah.
Interesting. Thank you.
Thank you very much, Representative Libby. Are there additional questions from committee members? See a question from the bill's sponsor, Senator Kime.
Thank you, Mr. Chair. Thank you for being here, Mr. Nygren. Just a question. You've mentioned a couple of times legally protected data that you need to keep, but if in fact this bill passed and then the child were to say, I give permission for this information, like wholesale, to be given to my parent, then wouldn't that change the directive about legally protected data?
Yeah, the challenge becomes how that consent might be obtained. So as I mentioned in my testimony, you can imagine bringing your child to a visit with them standing right next to you and the physician or whomever at the practice asking the child, do you give consent to your parent to see everything? They're sort of in a pickle at that point, because if they say yes, well, then they've just disclosed everything in their record, whether there's something confidential or not. If they say no, well, then the parent now has got suspicions about what may or may not be in that record. And so that simple asking of the question can set up a very impactful and negative dynamic between the parents. And so that's why there's really not a desire to go to that place where we're asking for the consent, because we've not established any standards around how that consent might be obtained.
So wouldn't it but couldn't you develop a policy around how you obtain consent if that's in private as opposed to in front of the parents?
Yeah, even so, I think the net is that when the parent goes to the practice later and asks the question about how they get access to this data, and they're told, well, we need to have consent from your child to do so. And then they ask, well, okay, haven't they given consent? And then they're told, no, they refused consent. Well, then irrespective of how we've asked the question, the same dynamic gets set up. It's a tough problem. As I said, we've been trying to think about the right ways to do this within the industry for a while, and there's not really a great solution yet. I think the real goal is to get to the point where we can discern the pieces of the chart that need to be protected, so that the vast majority of the data, and I recognize that this is the majority of the time, so that the vast majority of that data can be shared.
Thank you.
Senator Carney.
Thank you, Chair. Dr. Nygren, I wanted to ask you, is there a similar concern with regard to a minor at some point after giving consent, revoking consent? So for example, a 12-year-old might give full consent to access to the records, and then at a later point while still a minor. Can you speak with us about that a little bit, please?
Yeah, in essence, Senator, it sets up the exact same dynamic. In fact, probably even to a heightened degree. Oh my gosh, I used to have consent from the parent's point of view, but now my child has withdrawn that. It raises acute concerns, I would envision, from a parent's perspective. And again, why we've not gone down this path yet around the consenting approach.
Thank you, Senator Carney. Representative Libby.
Thank you, Mr. Chair. Dr. Nygren, I just want to clarify. So for a parent to have access to their child's records, you need to have a child's consent, but your practitioners are not allowed to get a child's consent. Is that correct?
Right now, for the portions of the record that are legally protected, the child is the only one that can obtain those, to my understanding of the law. And if the child in turn wants to share that with their parents, they're free to do so.
Follow up, Mr. Chair.
Yes, Representative Libby.
So how would you propose that a parent like Ms. White, who is trying to get her child's lab results for a month, do that?
Just the way that we've done it all, the time up until the advent of electronic portals. She could either reach out directly to her provider to ask for their interpretation of the data, the results of the data, or she can request for it to be obtained manually, and in some instances over the phone even. I know some practices do it that way.
So electronically is protected, but written and spoken is not.
Electronically is not protected. The pieces that are protected are the confidential pieces of the record. We're not able to currently separate the confidential from the non-confidential pieces of the record and share them in an electronic format. Therefore, our only option at this point is to withhold all of the record electronically, because we don't have the ability to tease out the sensitive versus the non-sensitive pieces.
Thank you. I am amazed that we can send a man to the moon, but we can't parse data on confidential versus not.
Well, it's a tougher problem than you might imagine, if I may.
I think it's okay. I think you've explained the records, the situation with electronic records. Senator Carney.
Yeah, I just think this is an inappropriate line of questioning for this, for Dr. Nygren. I mean, he's dealing with an electronic medical system that he did not, record system that he did not create. And it seems that he's being asked questions about something that is not in his control.
I think he's provided answers to the questions, and we've exhausted this topic at this point. Are there additional questions for Dr. Nygren? Seeing none, thank you very much for your time today, sir. And
thank you. Thanks for the opportunity.
Committee. The next person that I have registered to testify in opposition to LD 1510 is Dan Moran. Welcome back, Mr. Moran. I assume you're still coming to us from Gorham.
Yeah, I am. I'm not that quick.
Please.
Thank you, Representative Hartnett. Senator Carney, and Senator Carney, I used to live in that little small sliver of Scarborough that you represent. So, corner of Williamsburg and right near Benjamin Farm over there. So it's a great little part of the district. Again, members of the committee, my name is Dan Morin. I'm the Communications Director and Government Affairs Director for the Maine Medical Association. The association's located in Manchester, and I won't go over what we represent and who we represent. It's in the testimony, and we did go over it in the first bill before you, similar topic. First off, we would like to thank Senator Keim. She did reach out on this particular bill well in advance and actually had multiple email exchanges with Maine Medical Association's CEO, Andrew McLean, and it was very helpful to get the information and background from her on this bill as we prepared to provide testimony and get ready for the legislative session. So as indicated in the previous bill, most situations under state and federal laws for a minor to obtain healthcare services, the minor's parent or legal guardian must consent to those services, except in under certain circumstances, which we've heard at great length today. This bill could place a minor in an incredibly difficult position and potential conflict at home if you give the minor the choice to deny access to sensitive and statutorily covered treatment to a parent or guardian. It places such a burden on them, according to our members that we heard from, that it essentially eliminates the right in practical terms. One of the examples in the questions was, what if the parent, what if the kid wants to give consent? I mean, there are certain instances where I'm sure a parent will say, you're gonna give me consent when you go in there because I'm going to see your records. What position do you place a child or a minor in when it has to do with the statutorily protected provisions? State law, it's in my testimony, already allows physicians to override the minor's denial of consent on critical healthcare issues. And I actually put the specific statute there. If it's in the judgment of the practitioner or provider, failure to inform the parent or guardian will seriously jeopardize the health of the minor or limit the practitioner's ability to provide that treatment. So the information is accessible, just like Mr. Nygren said. It just has to be in a printed or on phone or whatever agreement you do come to with the physician, excluding the areas that are legally restricted. In some families, access to such information could be dire, and if you're asking why at a certain age, why is there a black and white age? Restricting access by age rather than choice is because it's automatic based. If you do it by choice, it could serve as a signal that the child has received a care of a sensitive type and raise an alarm to the parent and raise a concern to the parent that would put the minor in an untenable position, much like I described before. The minor has to have trust in their physician when they need to go to them for reproductive, mental health, or substance use disorder services. If they lose that trust, then care could be jeopardized, and ensuring that care is confidential is paramount to the physicians who care for their patients under this, except in the statutorily defined circumstances. And one final thing, you heard from Mr. Nygren on a bill earlier this session before health coverage, insurance, and financial services. I was asked about independent physician practices as opposed to hospitals and health systems. What's the most common type of health system and electronic health record? And what I found out is if you've seen one electronic health record, you've seen one electronic health record. I surveyed 15 to 20 members, and I only found 2 practices that use the same electronic health record. And when surveying them on this bill, they had the same feedback that technologically it just can't be done, but it can be done in other ways. Thanks.
Thank you very much, Mr. Morin. Are there questions from committee members for Mr. Morin? Representative Libby.
Thank you, Mr. Chair. Thank you for being here today, Mr. Morin. My question would be similar to previous questions. In the case of Ms. White and her daughter and their inability to access critical information for a month in the Maine health system, how would you suggest that parents address that? And it is not just Ms. White, but it is the folks who reached out to me regarding accessing their child's information. So if a parent isn't allowed to access it, but you're also not allowing the child to give permission for the parent to access it, how might one access that information?
You know, we get dozens and dozens of calls every week asking us about a range of issues, and this happens on occasion too. And we give them direction, and we actually reach out to some offices to link them up with people who have expressed concerns. If any of what I've told other committees that we present to before the session, if you have constituents come to you with concerns such as this relating to our members, please reach out to us and we'll do everything we can to help them in those instances. Mr. Nygren answered the question as far as it applies to Maine Health in the examples and the anecdotes you provided. I can't add anything more to what they could have done through Maine Health's process, but I can certainly give generally the same answer. You can call, and if a provider is not calling back in an appropriate amount of time and possibly withholding critical treatment, then that's a concern that the Board of Licensure may need to take up also. As I indicated in the previous bill, they're pretty diligent about addressing complaints, and if it leads to the delay of important, potentially life-saving care, that's a serious issue that even the Maine Medical Association would recommend that you contact the Board of Licensure on, so it can be appropriately addressed.
Thank you. Follow up, if I may, Mr. Chair.
Yes, Representative Libby.
I understand that Dr. Nygren's scope is more compressed than yours, so I wonder if you could outline how a minor would give consent for their parent to access their electronic record at this point.
I think I outlined it in the testimony. I mean, one, it can't be done electronically. It can be done in print. And aside from those statutorily prohibited and protected cases with substance use, reproductive and mental health, I mean, they certainly can. So I'm kind of misunderstanding the question. The information can be accessed, but technologically it can't through electronic medical records and independent practices, much like the large hospitals and health systems. Unless it's either all or nothing. And in order to protect that sensitive information, it has to be nothing at this point.
Okay, so one final follow-up, Mr. Chair.
Yes.
So your stance would be then that when Ms. White called the doctor's office to get the results, would be that the office acted inappropriately by not giving the information over the telephone, because that should have been granted?
See, that goes back to the bill before. I understand you're trying. I kind of think you're trying to do some mental gymnastics with me to try and say.
I honestly am not. I'm trying to figure out how a parent can access their child's very important medical information in the system that you have set up.
In that particular case, asking for blood results wouldn't be under statutory protections with reproductive mental health or substance use disorder unless the blood test had to do with reproductive care. And in that case, yeah, I mean, I would assume they would give it, but much like I said on the previous bill, when you hear anecdotes like this, because of HIPAA, we can't reply with our side of the story. Hospitals and physician practices can't apply. You know, you take as fact as what you hear in any committee or before any issue in the legislature when it comes to healthcare. But physicians' offices, clinics, hospitals, and health systems, we cannot. I don't even know. They can't even tell me what really happened or what their interpretation of the process is. So I can't answer. I was not there at the office when Miss White called. I don't know her particular situation nor her child's situation. So I can't answer that question.
Sure.
If you call me, if you send me an email and say, hey, Dan, it's Representative Libby, one of my constituents is having a problem with Jane Smith's pediatric practice in Mechanic Falls, then I can say, let me get your constituent in touch with the practice manager of Mechanic Falls so they can solve the problem, because I can't know any information. But if we get them together, we can come up with a solution.
And that's a fair point, Mr. Moore. So I appreciate you bringing that up. That is, let me rework the question. Take Ms. White out of the scenario entirely. Yep. Is it your understanding at this point, if it's not a reproductive or a mental health matter or something else covered by statute, protected by statute, if the parent called the practice and they were following up on an x-ray or a lab or something, no specific person, would a practice in your group be allowed to give that information out over the phone versus virtual where they can't separate the information?
the practice administrator and or the physician involved is in the best position to make that determination. I can't give you an answer to that hypothetical.
All right, thank you.
Are there additional questions for Mr. Moran? Seeing none, thank you very much for your testimony today and on the earlier bill. We greatly appreciate your input.
Thank you.
I have no persons registered to testify in opposition to LD 1510, but I will go to the attendee room to ask if there is anyone who does want to testify in opposition. Please raise your electronic hand. Seeing none, I would ask if there are any persons in the attendee room who wish to testify neither for nor against LD 1510 to please raise your electronic hand. And seeing none, having heard testimony from all those present who wish to provide testimony today, I will now close the public hearing on LD 1510. And that brings us to our final.
Mr. Chair, before we move on.
Yes, Representative Moriarty.
I'd just like to make a request for the work session. I know we've, in the materials, we have a number of cross references to various titles and sections and so forth. It would be useful for me to have a good, concise summary of all of the legally protected areas as far as medical information is concerned, and how information from within those areas can be disclosed.
Thank you for that. And I see our analyst nodding, and I imagine that you will have that information.
Okay, thanks.
Our committee. Senator Keim, I saw you have your hand up.
Yes, thank you. Before we move on to the other bill as well, I just wanted to make the committee aware that there have been some technical issues around the bills because they were rescheduled. And so there's an enormous amount of testimony on the May 6th date. And then there's additional testimony on today's date. And a number of people that had meant to speak and had waited all day on May 6th did not end up being here today. So I would appreciate it if you would just look at the volume of testimony that's been submitted on both bills. Thank you.
Thank you for pointing that out. And I wish we had a technological cure to that problem. It seems that we are hearing today, technology cannot solve all of our woes, but it is very important that all the testimony be considered. Thank you.
Yeah, and hopefully we can move the testimony into one location so that people can access it, because it's very difficult the way it is.
I will see what we can do to make that happen. That makes a lot of sense. Thank you. I will now open the public hearing on LD 1591, which is a resolve directing the Department of Agriculture, Conservation, and Forestry to identify places with offensive names and methods of changing those names. The sponsor of the resolve is Representative Talbot Ross, and I am told that, and indeed she is available. Representative Talbot Ross, welcome back to the Judiciary Committee. When you are ready to go, please present your resolve directing the Department of Agriculture, Conservation, and Forestry to identify places with offensive names and methods of changing those names. Thank you.
Well, thank you. And good afternoon. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Rachel Talbot Ross. I represent House District 40, which includes the Portland neighborhoods of Parkside, Bayside, East Bayside, Oakdale, and University of Southern Maine campus. I want to thank you for the opportunity to present LD 1591, resolve directing the Department of Agriculture, Conservation, and Forestry to identify places with offensive names and methods of changing those names. Members of this committee may recall from last summer that the state's official coastal island registry was abruptly taken down when 5 offensive place names were discovered on the list. In fact, it was the Portland Press Herald that first inquired about the names, prompting the state to take action. The words used in these names are not only deeply harmful and offensive, they are also forbidden by current Maine law. In fact, the state's original offensive place names law, LD 1661, was sponsored by my father, the Honorable Gerald E. Talbot, when he served in the legislature. and it has been in effect since 1977, almost 45 years ago. In 2001, a full 20 years ago, the legislature forbid the use of a derogatory term for Indigenous women as well. Yet somehow, despite these long-standing prohibitions, the 5 locations discovered last summer persisted for decades, listed on a state-maintained registry. And I will add, out of the 5 offensive names, 3 included the N-word and 2 included an offensive derogatory term for Indigenous women. I want to thank Commissioner Amanda Beal from the Department of Agriculture, Conservation, and Forestry for her swift action when the offensive place names were discovered to have them removed from the state and national database. I am also grateful to Robert Malvini, state geologist, state archivist Kate McBrien, and many other scholars, historians, and stakeholders who have worked with me over the last several months on a proposal before you today. LD 1591 seeks to continue our work to end the use of offensive place names in our state. I am presenting an amendment which is attached to this testimony for your reference and will speak to the proposed amendment instead of the bill as originally drafted. The bill would direct the Department of Agriculture, Conservation, and Forestry to work with the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations to review existing state law on offensive place names. The working group would be charged to do the following. 1, reviewing current law to determine and suggest any additional words that should be included in the current definition. The current definition of offensive names is found in MRS Title 1, Chapter 27, subsection 1101 under definitions. So the very first thing the working group would do is to review those definitions to see if they are complete, if we need to update them at all. The second thing the work group would do is review and consider any recommendations on the current process for renaming geographic features and other places that have offensive names. That is found in the same title and chapter, subsection 1104. So the work group would look at the process for renaming and make sure it is comprehensive, given the fact that last summer we found 5 offensive names. And third, the work group would explore the most effective methods of identifying any individuals, entities, and institutions in the state that have profited or benefited in any manner from the global economy of enslavement. LD 1591 directs the work group to submit a report to this committee on its work, including any suggested legislation by December 1st, 2021. It is my hope that this important task can be accomplished within the existing resources of the department and the commission. But if it is not the case, the amendment does provide a mechanism allowing the department and commission to accept available private and public resources to carry out this work. The continued use of offensive language in place names within our state sends a clear message to entire groups of people that they are not welcome or valued here. It is critical that we work together to ensure these harmful messages have no place in our beautiful, beloved state. I want to thank you for your consideration, and I would be happy to take any questions.
Thank you very much, Representative Talbot Ross, and thank you for bringing this bill forward to the committee, which is now this afternoon. And I would turn to committee members to see if they have any questions of the bill sponsors, Representative Talbot Ross, beginning with Representative Evangelos.
Thank you, Mr. Chair. Mr. Chair, I wanted to share something with the committee and with the bill sponsor. It's not a question, so if you would prefer I would testify in support of the bill, I'll handle it that way. I'll leave it at your discretion.
Why don't we will call on legislators next if they want to testify in support of the bill. So why don't you hold it for a short testimony?
You want me to leave my hand up or take it down?
I think I can remember. You can put your hand down. Representative Moriarty.
Thank you, Mr. Chair. Representative Talbot Ross, I am looking at the resolve that replaces the bill, and I certainly agree that paragraphs 1 and 2 can be accomplished by the joint efforts of the Department of Agriculture and Conservation Forestry and the Permanent Commission. Looking at number 3, though, I'm just wondering whether something like this ought to be delegated to the state historian or maybe the state library, as opposed to these to the department and the commission. It seems to me that it's going to involve a lot of digging around in old documents and some fairly intensive research among primary historical materials, which may be beyond the scope of the two organizations identified. Do you have any thoughts on that?
Well, thank you so much, Representative, for the question, because it gives me a chance to brag about the folks who would be involved. This working group would not be limited to the department and members of the Permanent Commission. They would form a work group that would involve the scholars and historians, the state archivists who actually have helped write this bill. They would be involved every step of the way, because you're right. The department and the commission are not scholars and historians to the degree that we would need. So you'll hear from individuals today. Kate McBrien, who is our brilliant state archivist, would be involved every step of the way in this process. Folks are eager to get to work. Some of you may know of Dr. Kate McMahon's work. She is from the state of Maine, a graduate from the University of Southern Maine, and she's now leading at the Smithsonian Institute work on the global slave trade. She would be intimately involved with this work. In fact, it's her work, along with Dr. Meadow Dibble from Brown University and from Atlantic Black Box. It is their work that actually brought this bill forward. Dr. McMahon, she is the one who discovered the islands from this past summer that were erroneously contained on the registry. So it's all of their work really that's coming forward, Representative. It's not the Permanent Commission or the department. It's just that the department and the commission are the conveners to bring our scholars and our historians and other stakeholders together for this process.
Good, helpful answer. Thank you.
Thank you, Representative Moriarty, and thank you for your response, Representative Talbot Ross. Representative Babbage, you have a question?
Actually, yes, I guess I do. I first wanted to comment about Representative Talbot Ross. It made me happy to hear you reference your father who I had the good fortune to meet long ago, and then again more recently. So, but I wondered if by chance you could put your testimony in the portal for us to see. I don't think it's there. Do you? It is
there.
It is there. It wasn't on my list. I'm sorry, but I shall refer to it. Thank you very much.
If I may, I just say thank you, Representative, for mentioning my father. What probably of the hordes of bills that I have this session, this one I'm probably the most proud of because it does pick up from the work that my father established almost 45 years ago. So I'm very, very proud of this particular bill because I get to honor him in the process. So thank you, Representative.
And Representative Babbage, you might want to refresh. It was submitted after our morning session began. Does that conclude your questioning, Representative Babbage?
It does. Thank you, Mr. Chair.
Thank you. If you could lower your electronic hand, that would be helpful. Are there questions from committee members for the bill sponsor, Representative Talbot Ross? Seeing none, again, thank you very much for bringing this bill forward to the committee. And as the bill sponsor, you're welcome to stay as a panelist if you would like till the hearing is concluded.
Thank you, Representative. I will just give one more honor, and that would be to the Honorable Donald Soktoma from the Passamaquoddy tribe and the Honorable Donna M. Loring from the Penobscot Nation, who helped make sure that the definitions also were expanded to include those that are offensive to Indigenous women. So I just want to give honor to those two fine representatives as well. So thank you.
Thank you very much, Representative. I will now ask if there are other legislators who would like to testify on the bill. Representative Evangelos, you indicated an interest. You're muted, Representative Evangelos.
Thank you, Mr. Chair. Senator Carney, Representative Harnett, and other members of the committee, I wanted to testify in support of the resolve brought forward by our colleague, Representative Talbot Ross. I actually wanted to share a story with Representative Talbot Ross. In 1976, I became town manager of the town of Warren. I was a kid town manager, and Warren had received a large community of African Americans after the Revolutionary War, led by a man named Charles Peters. And they settled in a section of town, segregated, and it was referred to as the Peterborough Settlement. The original founders had fought at the Battle of Bunker Hill. The settlement lasted until about the 1930s, but due to discrimination and lack of economic opportunity, it dwindled. Most of the members returned to urban areas for employment. But one of my titles in that job was road commissioner. And I don't know what a college boy knew about fixing roads, but it was a title they gave me. So I was out cruising and came upon that section of town, and we had road signs in town. And the road sign that was up in full public view on an intersection of a state highway, happens to be the same highway that the main state prison is located on today. The road sign said End Town Road. And there was a cemetery. It's called the Peterborough Cemetery. It was a segregated cemetery. It's still there. Although there's no signs up any longer. The gravestones are still there. And, you know, the folks in town referred to it as the End Town Cemetery. So I saw the road sign, and so the next select men and women's meeting, I went to the select board and I said, are you out of your mind? You got the sign out right on a state highway. And it was 1976. And oh, it's no problem. You know how it goes. Maine doesn't think it has a discrimination problem. And, you know, it's something, Representative Talbot Ross, you've been talking about, and these inherent biases that people have become blind to. Well, to make the story short, sign got taken down right away. But I just wanted to share that with you, that there are these unknown enclaves and communities of minorities that existed in Maine over periods of time. And almost without exception, they weren't called by a proper name. And thank you for bringing the bill forward. I'll answer any questions, but I don't need to. Thank you for that, Chair.
Thank you, Representative Evangelos. Are there any questions for Representative Evangelos? Seeing none, thank you very much for your testimony, Representative Evangelos. I will now, Representative Galgay-Reckett.
I'm inspired by Representative Evangelos's nerve to bring up his own story. But I also want to just take a brief moment to continue the honoring that Representative Ross has begun with this her testimony today. 45 years ago, I was a 31-year-old citizen lobbyist for the women's movement in this legislature, back when there was only one woman lobbyist in the whole entire state, and she represented Blue Cross Blue Shield. And that's when I first met Representative Talbot. And we worked together for many years, including the fact that he was the very first sponsor of the very first gay rights bill in this state. And he did that at my request, and I'm forever grateful to him for it, even though he was convinced we were going to pass it the first year instead of like 30, 40 years later, whenever the heck we finally did it. But in reality, he's a good man, and I'm happy to see that he's been honored in a couple of ways in recent years, with the naming of the auditorium at University of Southern Maine in his honor, and the naming of one of the elementary schools in Portland in his honor. And I think it's a really, he's a distinguished person in this state's history. And I think every chance we have to honor him while he's still alive to hear it is a really good thing. And so I'm happy to have probably bent the rules to do that in the context of this bill, but I'll be quiet now because sometimes I take direction. Thank you.
Thank you, Representative Reckett. I considered it testimony in support of the bill, and you were on a timer and you did just fine. Are there committee questions for Representative Reckett? Seeing none, again, I want to thank the bill sponsor for bringing the bill forward and for the legislators that testified in support of the bill. I will now turn to persons who have registered to testify in support of LD 1591, and I would recognize Robert Marvini from the Department of Agriculture, Conservation, and Forestry. Mr. Marvini, you can begin your 3-minute testimony as soon as you are comfortable, and welcome to the Judiciary Committee.
Yep, thank you very much. Good afternoon. Senator Carney, Representative Harnett, and members of the committee. My name is Robert Marvini, and I am the state geologist and director of the Bureau of Resource Information and Land Use Planning in the Department of Agriculture, Conservation, and Forestry. And I'm speaking in support of LD 1591 as amended by the sponsor. The department supports working with the Permanent Commission on the status of racial, indigenous, and Maine tribal populations in a working group to identify additional offensive terms and add them to the existing list found in statute in Title I. We will participate in the proposed work group to examine methods to identify other place names that may have negative historical connotations or meanings that require further review. The department's role is in facilitating the process to change offensive geographic names. In 2009, in response to LD 797 that added to the list of offensive names, we worked with municipalities, counties, and the federal government to ensure changes were made through the process described in Title I, Section 1104. The department has no expertise in the historical research proposed in Section 1, Part 3 of the amended bill to explore the most effective methods of identifying the individuals, entities, and institutions in the state that profited or benefited in any manner from the global economy of enslavement. But we will work with the commission, we will look to the commission to lead this effort. And it's our understanding that the commission may seek external resources to assist with this process, but we stand by ready to participate in the work group. So thank you for your time, and I'm happy to answer any questions now or in the work session.
Thank you for your testimony, Mr. Marvini. It's nice to see you again. I had the pleasure of serving on a board of a land trust with.
Good to see you, Representative Harnett.
Nice to see you. Are there questions from committee members for Mr. Marviny? Representative Thorne.
Thank you, Mr. Chair. Welcome, Mr. Marviny. Appreciate you coming today. And just curious if anyone has done a preliminary scan of these locations to preliminarily determine if there are any more that have been identified unofficially at this point.
Well, I think the question is, I think we need to look first at what names may be potentially offensive. There certainly could be many out there. And through the federal government, we have access to the Geographic Names Information System, a database of these geographic names that are used by federal agencies and state agencies for mapping, for electronic maps. When you go to Google Maps to find a route somewhere, it draws on this database. And so I've already scanned through that and know that, the names that are already on that list have been changed. So the question is, are there other names that are now should be added to that list and go through the process to have them changed? So it's once we have a list, it's pretty quick to go and identify specific places where the names need to be changed.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for Mr. Marviny from committee members? Seeing none, thank you. Representative Babbage.
Thank you. I didn't get a chance for my electronic hand, so thank you, Mr. Chair. Mr. Marviny, hello. As I look at the bill, we're talking about renaming geographic features and places and street signs, and I mean that's my understanding of the resolve. In number 3, the in any matter portion of that sentence, I think allows for a great deal of judgment and interpretation. And I wondered about decision making on the if you have any, whereas you've been working with the sponsor, and I should have asked the sponsor this, but how would the decision be made ultimately about the changing of the place names?
Well, so first, the work group, as proposed in this amendment, would develop a list of potential of terms that are considered offensive. That would have to go through a legislative process to amend Title I, Section 1101. That's the first part. The second part is that in Section 1104 of Title I, it lays out a process that municipalities go through with public meetings to discuss and propose changes to those offensive names, and also for counties in the unorganized territories. And once that part of the process is done, then my department would work with those local jurisdictions and the federal government to ensure that the geographic names database gets changed. So there's a public process at the local level to discuss and propose and make changes to those names. I hope that answers.
That was very clarifying. I appreciate it. Thank you so much. Thank you, Mr. Chair.
Thank you, Representative Babbage. Senator Keim.
Thank you. I have 2 questions. One, just following up on Representative Babbage. So, Mr. Marviny, did you say that the decision would be made by the group on which names had to be changed, or would that be going to a legislative process?
Well, the work group proposed in this bill would recommend changes that would have to come back to the legislature to change Title I, to amend the list in Title I. So that comes back through a legislative process.
Okay, so no names would be changed without a legislative process. Okay, thank
Correct.
you for clarifying. And then my second question was on the funding. It says that the working group shall carry out the responsibilities within existing resources, but then it also says they may solicit, accept, and expend funds to cover any expenses that are in excess of existing resources. Can you help me understand where you might be looking for those funds?
Well, that's a very good question, Senator Kime. Thanks for asking that. I think that my department can participate in the work group within existing resources. I think a question that came up in discussing this process was that some other participants in the work group may potentially need some compensation in order to be able to participate because that's not part of their current work, their current work setting. So in that case, well, my department wouldn't have resources, but I would hope that that the Permanent Commission on the indigenous peoples would have connections that may be able to raise funds from the private sector for that purpose. But I don't know the details on where those sources might be.
And so the commission would pay some people to be part of it, and others would do the work as part of their job that they're paid for already. Is that your understanding? Thank you. And thank you for the work session. I would like some more information around the funding, and apologies, I have to leave because apparently they are taking up my bill in education now.
Thank you, Senator Kime. Are there additional questions for Mr. Marvini? Seeing none, thank you. And let me just make sure I'm not missing anyone. Seeing none, thank you very much for providing your testimony this afternoon to the committee. The next person that I have registered to testify is Bay Love. Mr. Love, as soon as you are ready to provide your 3-minute testimony, which will be timed by my co-chair who's returned, please unmute your microphone and welcome to the Judiciary Committee.
Thank you so much. Thank you all so much for this critical work. My name is Bay Love. I reside in Portland, and I wanted to come today in favor of this bill. I actually do training. I'm trained as a business management consultant. I worked at a place called Boston Consulting Group, so really kind of come out of a business strategy background, but also have been involved in civil rights work and racial equity work for a long time. I work with a group called the Racial Equity Institute that trains nationally on these issues. You can hear us, you may have heard of some of you on the Seeing White podcast is something that we were featured on that has gotten relatively good coverage. And you can also, we have workshops actually locally and have had some people from the Maine legislature come. Would love to have any of you for that as well. But I say that to say this, that from our perspective as people who are involved in this racial equity work nationally, and as people who have also studied the business impact of racial equity, I just think that it is absolutely critical for our state to do everything that we can to demonstrate that we really are a state for everybody. And I think, as has been stated earlier, the history of racial discrimination, from our viewpoint is undeniable. I know there are some people that deny it, but I think the record speaks for itself. And while changing names is only one step in a much deeper process that we need to take, it's a critical step. It's a critical step because it demonstrates commitment. It creates an environment where people know that they're welcome. But as a white man, I stand before you today, too, to say that it also creates an environment for people like me to be able to see and understand the depth of racial inequity that's characterized, the history of this state, which I love so much. My great-great-grandfather was a Supreme Court justice in the state of Maine, Henry Clay Peabody. You can check him out, Bowdoin graduate, other parts of my family have been in the state since the 1700s in Oxford County. And, we purchased land through a land grant program that would have only been available to white people in the 1700s. And that land was Abenaki land. And that's just a part of our history. And I think that, for us to be able to stand together as the state of Maine that we really want to be, we've got to take this on. So thank you all so much. I'm sorry for being a little bit emotional. This feels quite personal. Thank you.
Thank you very much for providing your testimony to the committee today, Mr. Love. Are there questions from committee members? Seeing none, again, thank you very much for your time, and the committee very much welcomes your input. Much appreciated.
Thank you all so much.
The next person who will testify is Bethany LaCroix. I hope I'm saying that right. And when you are ready, please unmute your mic, activate your video, and begin your 3-minute testimony.
Hello, thank you. I appreciate you guys having me on here. I don't have any credentials to speak of, but I'm a mom in Gorham, and my testimony is as follows. Good morning, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Bethany LaCroix, and I live in Gorham. I recently heard about LD 1591 and would like to testify as to my support for the bill. I am pleased that the bill will direct the identification of place names that are offensive and then work towards the best methods for changing those names. I believe that by removing names that are deemed offensive, we can reduce harm to future generations in Maine. By removing hurtful and hateful words and phrases from our daily conversations, I have confidence that the committee that will be formed can formulate recommendations to not only strike offensive names from our maps, but to also retain the historical significance of these places, honoring ideas and names that we can all be proud of. Thank you for your time and consideration.
Thank you very much for joining the committee today and presenting your testimony, Ms. LaCroix.
Thank you.
I'm going to ask members have questions for you. Are there questions from committee members? Ms. LaCroix? Seeing none, again, thank you very much for your testimony, which I noted. And
thank you, I appreciate it.
Noted Mr. Love's was provided online as well. Thank you.
Thank you.
The next person I will call is Meadow Dibble. Please begin your testimony as soon as you are comfortable, and welcome to the Judiciary Committee.
Well, thank you so much. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Meadow Dibble, and I live in Portland. It is both as a resident of Maine and as director of Atlantic Black Box that I am here to testify in support of LD 1591, a resolve directing the Department of Agriculture, Conservation, and Forestry to identify places with offensive names and methods of changing those names. Atlantic Black Box is a public history project devoted to researching and reckoning with New England's role in the slave trade and the global economy of enslavement throughout the 17th through 19th centuries. As a coalition of scholars, history professionals, descendants, and community leaders, we give citizens the tools and the support that they need to help uncover this region's hidden history of complicity in slavery, just as we provide communities with the means to recover and recenter stories related to the free and enslaved Black and Indigenous populations that once lived and labored in Maine and throughout New England. LD 1591 is a critical piece of legislation. Offensive place names do not just mar our landscapes. By dehumanizing certain groups, they cause harm to our fellow citizens, and they undermine our efforts to build diverse and equitable communities. When mountains, islands, hills, and brooks are identified by racial slurs, those spaces communicate through their very names the notion that some people belong and are welcome here and others not, skewing our sense of collective identity as Mainers. Similarly, When towns, streets, and entire counties are named after prominent forebears who earned their wealth and advantages through slave trading and investment in the economy of enslavement, those names communicate our values as a community. It is well past time that we conducted a thorough audit of place names and embarked on a sustained, well-informed conversation about the values we wish to uphold and to project. As you've already heard, it was in 1977 that Representative Gerald Talbot sponsored a bill to remove the N-word racial slur from place names in the state of Maine, of which at the time he had counted 10. The passing of that law made national headlines. 43 years later, Representative Rachel Talbot Ross was rightfully aghast to learn that her father's bill had not been effectively enforced when it came to light last summer that 5 Maine islands and a number of other sites in the state continued to bear offensive names that should have been changed 4 decades ago.
Ms. Dibble, I apologize for interrupting. We do have a 3-minute clock that we try to maintain. So you could wrap up your testimony in 1 sentence. That would be greatly appreciated.
I would just like to thank you. I would just like to say that while grassroots initiatives to change place names at the local level should absolutely be encouraged, such as the vote that took place last weekend in Castine, we cannot leave this as a local control issue. The question of whether or not to eliminate racial slurs from our maps and our landscapes. This is truly a matter of protecting the dignity and humanity of all. Thank you.
Thank you very much for your testimony today, Ms. Dibble. The committee greatly appreciates the input. And I will now ask committee members if they have any questions for you about your testimony. Committee members, are there any questions for Ms. Dibble? Seeing none, again, I thank you very much for your input today. And I thank you for, I believe you submitted testimony online as well. And if you haven't, if you could submit it through the portal, that would be very helpful.
Thank you, I will.
Thank you. And I will now call on Susan Stark. Ms. Stark, please begin your testimony as soon as you feel comfortable, and welcome to the Judiciary Committee.
Thank you for having me. Can you hear me all right?
Hear you just fine. Thank you.
Great. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Committee. My name is Susan Stark, and I live in Falmouth. I'm here to speak in support of LD 1591. My deepest thanks first to Representative Talbot Ross for introducing LD 1591. I am a faculty member at Bates College, and my areas of study include the study of the way our uses of language reflects the values that we hold. There remain place names in Maine that are offensive. Some of these names were words common to use during the decades of Jim Crow segregation, when lynchings of Black and brown people occurred publicly and frequently, and were acts of terrorism toward all Black and brown people. These words and these acts of violence and terror devalue the humanity of Black and brown people. The state of Maine also uses place names that are derogatory toward Native and Indigenous people. To keep these names perpetuates the wrongs of violence, terror, and genocide, and continues to cause trauma and harm in the present. There is no reason to keep these names. If the state of Maine, the leaders of our state, and the people of Maine are to value the humanity of all humans, there is no choice but to identify all of the place names within our state that devalue humanity, to identify a method to change those names, and to enact that process of changing these names. There is so much beauty in the state of Maine, and so it should be easy to identify alternative names, names that celebrate the natural beauty of Maine, and most importantly, names that do not devalue the humanity of some individuals and groups. When we devalue the humanity of some, we devalue the humanity of all. Thank you for hearing my testimony.
Thank you very much, Ms. Stark, and thank you for providing your testimony to the Judiciary Committee this afternoon. We greatly value your input. Are there questions from committee members for Ms. Stark? Again, seeing none, thank you very much for your input. Your presence is very much appreciated. That is the end of the list of persons that I have registered to testify in support of LD 1591, but I will check the attendee room to make sure there is no other persons who wish to testify in favor of LD 1591. If there are, please raise your electronic hand so that we can hear your testimony. And seeing none, I would ask if there are any persons in attendance who wish to testify in opposition to LD 1591 to please raise your electronic hand. And seeing none, I will finally ask if there are any persons in attendance who wish to testify neither for nor against LD 1591 to please raise your electronic hand. And again, seeing none, having heard testimony from those present today wishing to provide input to the committee, I now close the public hearing on LD 1591. As always, I want to thank the sponsor for bringing this bill forward and for all those who took time out of their day to testify. And with
Thank
that,
you all.
thank you, Representative. And with that, we end our public hearings for this morning. The committee will come back into session at 2 o'clock this afternoon for a series of work sessions for Democrats on the committee. We will try to caucus at 1:30. Representative Evangelos, you have something before we adjourn till 2 o'clock?
Yeah, just very briefly. It's my understanding that the $1 billion package that came out from the governor did not include money for indigent legal. Do you have any other information on that?
I do not. That's my understanding as well. I do know that the committee will be hearing 3 bills on the Maine Commission of Indigent Legal Services a week from tomorrow that they will express the committee's view about how that matter should be handled.
Okay, thanks a lot for that.
You're very welcome. If there's nothing else from committee members, I will see you all at 2 o'clock. Up, Representative Thorne.
On the schedule for the day, the one that I have, there's a 1 o'clock amendment review. Is that not happening?
I am sorry. Yesterday, our analyst, Peggy Ryan, said we only have amendment reviews when she's able to provide the amendments at least 24 hours in advance. She was unable to keep that schedule because we're keeping her so busy in committee. So that is not going to be had. So you can enjoy that hour.
See you at 2.
Okay. Thank you.
Bye-bye.
Okay. See you
And
soon.
remember to mute your mics and shut off your video.
I see a daydream. It's a good day for it.
Committee members, it's a little bit after 2, so if you are here, please activate your audio and video. Or actually just your video. Thanks. All right, good afternoon, everyone. We are here to do work sessions on a number of bills. We have a couple of different bills, and I think we will do them in the order listed, starting with LD, I gotta put my reading glasses on. LD 331 and 864, and then we'll take up the remote participation bills all at once. And I just want to remind members of the public and those who are attendees as well as panelists, the work session is really our opportunity to discuss and vote on bills as a committee. There may be occasions when we need someone who is here as an attendee to answer a specific question, in which case we can pull them in from the attendee panel. But generally, this is really a time for committee discussion. We do invite bill sponsors to be on the panel during the work session for their bill, and we often give them an opportunity to speak with us about any additional items on that bill. And so with that, I will open up the work session on LD 331. And the bill sponsor is Representative McCrate. And Supi, could you please bring Representative McCrate onto the panel? Thank you. Welcome, Representative McCrate. We're just about to dive into 331. And so Peggy, if you could begin with your bill analysis, please.
I would be happy to. Thank you very much. LD 331 is an act to protect student privacy. It amends the Freedom of Access Act, the definition of public records. Under the Freedom of Access Act, the definition of public records is really any record of any type that is in the possession or custody of a governmental entity that was created or maintained or kept because of governmental functions, unless there's an exception. And so what this bill does is add to the exceptions. The exception you don't see here is anything that the statute says is confidential. That is an exception to what is a public record. This bill adds 2 more things. Paragraph W is video and audio recordings made by security or surveillance cameras on school grounds. And a new paragraph X, any live or recorded interactive lessons or classes taught by public school staff for which public school students, for public school students, and shared through electronic platforms or recordings in which students can be seen or heard. And just a quick thing about public records is if something's a public record, that means the public has a right to it. If there is confidential information in it, that needs to be redacted before the record is turned over or inspected. The public doesn't have to get a copy. They should be able to inspect records if there's something in a format that can be inspected. But a public record means the public has a right to it. If something is not a public record, these are exceptions to public records. That means the public does not have a right to demand it. It doesn't mean that the record custodian can't provide it. The record custodian is still always required to redact or protect confidential information. So these are exceptions. It means they're not public records. Saying it's an exception doesn't necessarily make it confidential. When you make a record confidential, then you should probably write in the statute what are the exceptions, or who can that be shared with. This is not saying these records are confidential, it's just saying the public does not have a right to see them or demand them. Are there any questions?
Go ahead, Representative Harnett.
Thank you, Madam Chair. Thank you, Peggy. And I should know the answer to this, but I just want to be sure that I am correct. One of the concerns we've heard about making these records not available to the public is that there could be public safety concerns if schools are not allowed to turn records over to law enforcement agencies where students' safety or public safety might be at risk. There is nothing that prevents schools from working with law enforcement agencies if that is necessary with these documents, or am I wrong there?
No, that's my understanding as well. If this passed, there's nothing that would stop the school from providing these records to law enforcement or other agencies in the school district to follow up on anything.
Or to a family whose student might be impacted by conduct in a school?
Correct.
Thank you.
Thank you, Representative Harnett. Representative Thorne?
Thank you, Madam Chair. My question, Peggy, also is close to Representative Harnett's, but it gets into the more, can a family demand that surveillance in a bus, for example, gets turned over to them or to a representative for viewing, versus allows the school the liberty to turn it over?
Right.
I'm curious where that verbiage differentiates.
Right. That's a good question. Obviously, a parent could demand that it be turned over. Because it's not a public record, it wouldn't be requested as a public record. So it would be requested as some other record within the school. And I'm not exactly sure what rules apply to that kind of sharing, but if the parent felt that they were being stonewalled, they could actually ask for that record. They could go to court and ask for it. And I believe that's what has happened in some of the other videos. And yeah.
In other words, if the school, for whatever reason, opted not to turn it over, the other recourse the parent would then have to take civil action in order to obtain that footage.
Right. I think that might be right.
Okay, thank you.
I have a question for you, Peggy, as well. So this is a bill that would actually have to come back to our own committee for a freedom of access review. Is that right?
Yes, it is.
Okay, thank you. Any other questions for Peggy? I'm going to just ask the bill sponsor if she'd like to speak with regard to the bill. Go ahead, Representative McCray.
Thank you, Chair Carney and committee. No, I think you asked great questions. I would just say if there are technical questions and you wanted to ask, I think Steve Bailey is in the waiting room. You might be better able to answer. Thank you.
Yeah, thank you, Representative McCray. I actually would like to bring Steve Bailey in, and the question I would ask him is, I think the question that Peggy suggested of are there rights that parents have that are independent of the Freedom of Access Act to get, for example, the video on the bus or whatever the document might be. So I'm going to bring him onto the panel. Welcome, Mr. Bailey.
Good afternoon.
You initially appeared sideways.
How are you, Senator Carney? Good to be here. Okay.
Thank you. We're glad you're here.
Is this better now?
Much. Thank you. The question that I would like to ask you is, We understand that this legislation proposes making video and audio recordings not public records under the Freedom of Access Act. However, is there a separate provision, perhaps under education law, that would give parents a right kind of outside of the context of the Freedom of Access Act that would give parents a right to audio or video recording involving their particular child?
Regarding their particular child, yes, and this in most instances deals with disciplinary considerations or concerns where an act may have happened where their child may have been involved, and in that particular instance, it's not uncommon for a parent to request, as well as say a school principal to request a parent to come in and actually view video, while at the same time we have to be very cautious that they're not viewing other children, but they're viewing their own child with regard to what the situation was and how it was involved.
So just a follow-up question. So if my child were punched in the nose on the school bus and there was a video recording of it, would I, under the law or regulation that you were just referencing, would I have a right, an absolute right to that, to view that video?
I think that is going to depend on the situation in terms of absolute right. I think that could be requested. Whether or not that was needed, I don't know that it would be an absolute right.
If my child were potentially subject to discipline for punching another child in the nose on the school bus, would I have a right to see that video?
Yes.
Okay, thank you.
And those are the situations that I would reference in terms of where that particular situation would be shared to be able to help bring context to the situation.
Thank you. Representative Thorne, did you have a question for Mr. Bailey?
I did, and I'm just wondering what this bill would change from how things are done today and what that advantage would be to the public at large. I mean, has student privacy been exploited recently, or?
Yes, it has, and it's not in Maine, but it's one that we're concerned about, and it does it did result from a Pennsylvania case where that information were to be able to be viewed publicly. Then the privacy of students would be shared, and not rightfully so, in terms of without the permission of parents, in terms of having that information be shared. So in the instance that Senator Carney was speaking of, it was the right of the parent, or it was the ability of the parent to come and see the situation. It wouldn't be the right of, let's say, the press or other viewers who would seek that information to be able to use it for their own device or their own advantage. And that's the worry that we have with regard to student privacy not being protected.
So am I correct in assuming this is basically a measure to prevent the press from exploiting a particular situation that happens at school grounds?
Excuse me, I didn't mean to interrupt. I don't think that it's for the press per se. I think it's more in terms of other, be it predators or other potential misusers of information that would have access to it. And I'm not characterizing the press in that particular way.
Okay, and I'm just wondering if currently you say predators, and I'm just trying to clear my head of the approach on this. To get access to information currently still have to go through the school, right? But if I don't have a student in the school, I'm not a member of the press, can I go in and request video footage from bus 38?
Well, if it's a freedom of access request, yes, you could.
But would he get it if it were a freedom of, if he was under this bill? If he were a person
under this bill, no.
Okay.
But currently, yes,
Potentially.
potentially. Okay, thank you. That helps.
Senator Kime?
Thank you. Mr. Bailey, I have a couple of clarifying questions. So first of all, you said potentially they could get access. I think I need clarification on that. And the second question I have is, you said that predators gained access to video footage of students in other states. And did they do that through a freedom of access request? Or how was that video footage obtained and used by predators in other states?
I apologize. I don't have the case in front of me. I would have to go back and review that in terms of how that actually was obtained. But that was the case that this proposed legislation was based on.
Right. So I guess knowing that would be important to this legislation.
If I can find that before the end of the work session, I'll get that back to you.
Very good. And then you said possibly that the information could be gained by freedom of access requests.
It would be dependent upon the request for sure, and it would have to be given due diligence in terms of the intent of the request for the school district to abide by it. And obviously the Freedom of Access Act requirements would have to be followed in order to be able to abide by the law.
I wonder if there's someone else that could answer my question a little more concretely.
Do you have access to the attendee space, Senator Kime? Are you able to view that?
I guess if there's someone that could answer my question more concretely, I would appreciate if they raised their hand to let us know, because I don't feel like that answer is sufficient to what I'm asking.
So, I mean, maybe I could just add a little bit. One of the things that Mr. Bailey has to deal with is the federal law, FERPA. And so there's a balancing that goes on in looking at these records. There's the freedom of access piece of it, where the public has access to any kind of record that's maintained by a public entity. And then there's FERPA, which protects, I don't know the exact language, but it protects personally identifying information about students and their academic records. So there was a question about how much FERPA applies on a school bus. I mean, we know it applies in a classroom. We're not sure how much it applies or in what situations it applies on a school bus or on the school grounds. And so that in some cases, that's going to be a case-by-case basis. And in other situations, it's going to say there is no protection from FERPA. There's also a certain amount of protection for school employees about disciplinary information. But if you're talking about school student records, then FERPA is really, and I think Maine just tracks FERPA. FERPA is going to be the guiding big restriction on what can be released about students. I don't know if that answers your question enough, but I think that's one more layer in the cake.
Right, which is something I kind of wanted to layer onto this, because personal identifying information could possibly be someone's face, not just necessarily the records, their school records is what I'm wondering. And do you then know how the information or the footage was gained for the other states that Mr. Bailey is discussing? Like, was it through a freedom of access request? Do you know, Peggy?
I believe the bus, because this came up in Right to Know a couple of years ago. I believe the bus video was accessed through a freedom of access. I think that's right. The video of the child that was being disciplined and dragged down the hall. My understanding is that was actually obtained by the parents through a subpoena. So that wasn't a public record issue so much as the parents trying to identify what was happening in that situation.
Thank you for that. That's helpful. But also it's so helpful to understand the exact situations when we're trying to craft law to address the situation. But I guess what I don't understand is the situation where perpetrators got a hold of video footage. How did they get it? Do you know that?
I don't know. I do know that.
Or predators, I think was the word he used.
Right.
Maybe.
Right. I know that's a concern, and some of the testimony, and this isn't really answering the question about actually getting video, but there was a concern in the Bangor Public Library. Mr. Nicholas, the city attorney for Bangor, was on Right to Know, and he said that there was a concern because somebody had seen a child dancing around in the library and asked for the video of that girl because he was interested in watching the video of the child. And it turned out that the library was not a public entity, so it wasn't subject to the Freedom of Access law. But if it had been, they would have had to turn over that video upon that request. And so that they didn't have to. We don't know if this was a predator. It was somebody who didn't know the child. But it worried at least one member of the Right to Know Advisory Committee that he thought the bill should be even broader. In fact, when the bill in the 129th, a bill similar to this was in the Education Committee, and the city of Bangor asked for it to be broadened to be security and surveillance cameras on any public property. So nobody's asking you to expand this bill. FERPA wouldn't apply in those situations. FERPA does apply in what this bill is intending to address. So in short, I can't answer your question because I don't know about the videos in other states.
Great. Thank you so much, though. I appreciate your help.
Representative Harnett.
Thank you. And this is a question for Peggy and maybe for Mr. Bailey as well. Isn't one of the concerns here that if we make these videos, if these videos are public record, not only do they have to be turned over upon request from any member of the public, but they also have to be retained. No?
The Freedom of Access law does not specify how long any record has to be retained. There's a different section of statute. The archivist and the Archives Advisory Board put together record retention schedules. The statute says every public entity is supposed to abide by those record retention schedules. The fact that you make something a public record does not mean you have to retain it because it's a public record. The record retention schedules apply. And actually, I have the school schedule right now. This is local school records, surveillance records, which are recordings which document the activities in public areas of school facilities used as a security measure in the identification of persons who cause disturbances or violate laws. That's the description. The retention is retain until determined that no security incident has occurred, then destroy. So no incident, you review it, no incident, you can destroy it. If an incident or investigation is necessary, that is retained until it's resolved. But the fact that you're calling something a public record doesn't mean, oh, you have to hold it for 10 years or 5 years or whatever. It's the records retention schedule that directs that.
Is it a violation of law, though, to destroy a record that is a public record before?
I believe it is, and I will try to find that.
Thank you.
I was muted. It seems like there are unresolved questions. Does the committee feel like we are going to be able to vote on this today? Or do we feel like we would like to, and I see that Mr. Bailey has his hand raised, but let me just finish my question. What I'd like committee members to think about is whether we're going to be able to resolve this today or whether we feel that we do need the additional information. And now, Mr. Bailey, go ahead.
Thank you, Senator Carney. I did find the case from Pennsylvania that was obtained through a Pennsylvania's right to know law. It was a request through the Pennsylvania right to know law.
And the requester was successful in receiving the information?
Yes.
Was the requester a parent?
Oh, excuse me. The school district denied the request. I think it was followed through, and that was something that was made available. The requester was the Express Times, so it was a reporter.
All right, thank you. Lots of hands up. Senator Keim, did you have your hand up? Residual or?
No, I have my hand up. So if Mr. Bailey could, since he found the actual case, so it was Pennsylvania, and it was actually not a perpetrator or someone who was preying on children. It was the press that asked for the information. It was denied
By the school district, yes.
And that's the case that brought this bill to us?
Yes, and it was taken further. The trial court rejected the school district's argument that the video recording was exempt from disclosure.
Okay.
Under their right to know law.
Okay, but then the video was used in some sort of negative fashion after that?
No, I don't believe that was this particular case.
Okay, thank you.
Thank you, Senator Keim. Thank you, Mr. Bailey. Representative Thorne?
Thank you, Madam Chair. And I guess where I am now, you asked the question, but there seems to be lines drawn of where the right to know, Freedom of Access Act, FERPA, and does this supersede that and override it, or would it, prevent somebody from gaining that information? Would it be a shield to hide behind, I guess, if for some reason they didn't want to release it, or it was damning to the school or somebody at the school, that they could use this and say, no, we can't release it. We don't have to. That's I guess my question at this point. I don't want to see something that is intended to be good misused or turned around and to hide something down the road that is possible that we couldn't gain access because it violated another law besides right to know or FOA or FERPA. That's my confusion right now. Thank you.
Thank you, Representative Thorne. Representative Libby?
Thank you, Madam Chair. I'm trying to figure out I understand the intent to protect students, but it seems like this is coming out of the request was from the press in Pennsylvania, and that's part of where this is coming from. Is the intent of the bill simply to block press from getting information related to students or incidents that have happened involving students? It seems to be merging very close to that intent to me. If someone can point me to some nefarious circumstances that have occurred concretely, I would be appreciative.
I can't point you to any nefarious circumstances, Representative Libby. I guess one of my concerns, and it's actually particularly with Section 4 of the bill, which is paragraph X that relates to live or recorded interactive video lessons and classes. With in the last year plus, we have all of this remote education footage, which shows children in their homes and displays, I think, a lot more private information about children and their living situations that wasn't generated before the pandemic. And I am actually more sensitive to family and child privacy arising out of the way we've had to do education than I am about the nefarious circumstances. I just feel like it's really intrusive on parents and children if members of the public can see this video footage of children, in their kitchen or their living room or their bedroom receiving education. It just doesn't, it seems so removed from the way the access to people's homes than that we're used to. So that's where I'm coming from rather than the nefariousness. Let's see, go ahead, Senator Khan or Representative Libby.
Thank you. Yeah, well, I just would like to follow up. I did bring this up at one of the public hearings, and I think I guess the more appropriate time, as I was told then, would be now. I'm very concerned about students' privacy, but particularly in the way that numerous cases have transpired that students' privacy has been invaded by teachers when they have misinterpreted things going on in the home. And this has occurred in many states now. I can list off the cases if I need to, but in some of these cases, the press has been instrumental to make sure that information gets out about these cases, and I would not want that to be stifled. When a teacher sees a Nerf gun in a student's home, and that home is then invaded by police to investigate, or DHHS is called and involved, I think the press has been absolutely instrumental to making sure that a wrong is not done in these cases. And I would not want to see harm, of course, come to any student, but I am concerned that this could, in fact, have the effect of really stifling getting the truth out there in some cases.
Thank you, Representative Libby. Let's get some other voices on the table. Go ahead, Representative Hagan.
Thank you very much, Madam Chair. As you know, I just got out of school and I'm here. And I had a pretty large conference today with my assistant superintendent, excuse me. This may be a question from Mr. Bailey, who I see is still, or I think is still there, my former basketball coach in 8th grade. That's a long time ago. But anyway, so far I haven't seen, and I was curious as to, there was an example of a bus driver drinking a beer on the bus and things like that. And I just heard the word nefarious acts. So I came in the middle of that. So I have absolutely no idea what that talk was about. But at what point in the process does the press have the ability to get the videos of the interpretations of when I do my Zoom classes from, let's say, a parent's not pleased with something that happened in my class or a bus thing? At what point would the press have access to those kinds of things under this bill?
Is that a question for Peggy?
I have no idea. It's just a question that's been in my mind for quite a while.
Okay.
And
Yeah,
you
let's
guys-
give Peggy a
you guys
chance.
make the big bucks.
Yeah, let's give Peggy, if you're able to address it, Peggy. Thanks. Under this bill.
Right. If you could repeat it, I was busy looking for the FERPA.
Oh, thank you. I think that
I'm very sorry, Representative Hagan. If you could just narrow that down again for
You
me.
only work 23 hours a day, so I'm getting
I
kind of
know.
upset.
You caught me on my hour off.
So I was curious as to the process, and for whatever reason, I've missed it. At what point in the process of LD 331 would the media be allowed access to varying types of things, whether they're Zoom classes with my class or anybody else, or bus surveillance video, or things like that?
Right. So this bill would say they would not have the right to demand access. They could ask for it, but they wouldn't have a right to get it. So even if it weren't, if you don't, current law without this bill, there would be restrictions on what they would be able to get, because if they were, videos, information about students, that would be limited also. But under this bill, it looks like that they would not have a right to have any of it. If the school wanted to release it, they could do that.
Can I do one follow-up?
Yes, go ahead.
Thank you very much. And what about law enforcement? I am interpreting under this bill that law enforcement does have the right to have this, any kind of thing. I just want to make sure.
Right. So this is the Freedom of Access Act, and it's defining the public's right to records. And public has a right to records unless they specifically say in this act or somewhere else that they don't. So this doesn't actually address law enforcement access to the records. So to the extent law enforcement has access to those records, as functioning law enforcement agencies, they would continue to have access to those records. If it's somebody who happens to be a law enforcement officer that's just interested in what's going on and they're not asking it for the administration of criminal justice, then the school would be within its rights to not provide that if the school didn't want to.
Thank you very much.
Thanks, Peggy, and thanks, Representative Hagan. Representative Reckitt, go ahead.
I'm concerned about, me and domestic violence, everything's, you can't work in that field for 50 years and not be suspicious by nature. So I'm concerned about parental perpetrators or parents who are allowed only limited contact with students, making requests in a way that is that's not actually true, to try to get access to surveillance of their children who they may be allowed to see an afternoon a week and every other weekend, and might try to get video observation of either classrooms or wherever the kid is, in order to subvert the intent of the court. And not so much that they would do direct harm to the children that way, but I think that were the students to know that was a possibility, there'd be a chilling effect on them if they're in fact frightened of this person or concerned about this person or whatever. So I'm my brain, it went there, which even though I know that's not really on point with this bill, it's certainly closely related. And so I'm less concerned about the press getting access or not getting access than I am about individuals, individual parents or individual other people in the community.
Thank you, Representative Reckitt. Representative Moriarty? Representative, we can't hear you.
I'm sorry. I think we began our session before Representative Hagan joined us. Peggy, I believe we began with your analysis, and that you pointed out that if there were a violation of law involved or alleged, that law enforcement would have access to whatever records existed pertinent to that allegation, including video.
Right.
It's not a freedom of access request. It's a criminal investigation.
Correct.
So law enforcement would have access to this if necessary.
I would assume so. I don't know if there are any restrictions that I don't know of any restrictions that law enforcement would be subject to in order to investigate.
And by the And by the same token, if there were student disciplinary proceedings that resulted from an incident, the parents of the students involved would have access through the school administration as well.
That's Mr. Bailey's bailiwick.
I heard him
That
say
is what he said.
Yes.
and then I heard some slight backing away. So, but I thought his first comment was right, that yes, I mean, if my kid is being punished for having alleged to have done something, I think I have the right to get that, to see that video, not as a FOA request, but as sort of a party, an interested party to the proceeding.
Yes, that's correct. Yes.
Okay, all right. So I think we can agree that the bill limits routine FOA type requests for all this quantity of video that's been generated through the remote learning process, but doesn't stand in the way of law enforcement or parental access incidental to disciplinary proceedings or something analogous to that. That's my take on this.
That seems accurate to me.
I'm prepared to make a motion. I don't want to cut off debate.
Why don't you make a motion and then we can, if it is seconded or regardless, but why don't you make a motion and then we can continue with discussion of the bill.
Okay, my motion is ought to pass.
Okay, is there a second? Seconded by Representative Reckitt. And now we'll move on to committee discussion. Before we do that, Christopher Parr is here, and I think that I just want to check with committee members and see if there's any outstanding questions about law enforcement access to this information were this bill to pass. If you do have that concern, please actually just raise your real hand because there's some electronic hands up. Okay, so it looks like Representative Hagan, looks like there are 3 folks who have questions for Christopher Parr, so I'm going to bring him onto the panel and we will proceed with those 3 questions.
Madam Chair, I'm going to turn off my camera so everybody else has room on. Oh, maybe the screen expands.
Yeah, okay. Thank you.
Never mind.
Okay, I think we can all see each other.
Okay.
And I'm just going to call on folks. Let's see, Representative Hagan, why don't you go first with your question?
Okay, thank you. It's the same question. I wanted to know, in the process, what if this bill does pass, it's signed into law and all that, are the police, law enforcement agencies allowed to get the information? I know the press can't, according to this, but is law enforcement able to still do all of its job unencumbered by this bill?
Thank you for the question. My name is Chris Parr. I'm here in my capacity as a member of the Right to Know Advisory Committee, not here on behalf of the administration or the department or Maine State Police. So I just want to make sure I'm clear on that point. I do think Peggy's right as far as her analysis. That said, as a lawyer, I always like it better when if it were expressly stated. For example, if the bill expressly stated that in this case, given the concerns that have been discussed, that access would be allowed for not only law enforcement purposes necessarily, but for parents to be able to access when appropriate. That would just be my preference. I think there are certainly court procedures that could be followed if for some reason there was a determination that law enforcement wouldn't have access through this. So I hope that answers your question.
Thank you very much. I don't know if that answers the questions that other members who were raising their physical hands had, but if you still have a question for Christopher Parr and would like to ask it, please raise your physical hand. I think you addressed everybody's questions. Okay, are there any other questions for Christopher Parr? Go ahead, Representative Libby.
Thank you, Madam Chair. I just realized I did have a further question. I guess my question would be, at what point can law enforcement, and I guess this is asking you to put on your law enforcement hat, at what point could law enforcement get involved? If a child said, as in this, as in this Pennsylvania case, a child said that they had been roughly disciplined on a school bus, if that parent makes a complaint to the school or whomever, would the police be able to request that video just on that child's say so? A 6-year-old tells their mom, my bus driver did whatever. Is that enough for law enforcement to get involved?
Thank you for the question. I mean, I think it's always going to be fact dependent, but certainly if there's a serious allegation such as that, and it's reported, presuming that the police are made aware of it as well, I think that the law enforcement would find it appropriate to look into that. I mean, it sounds like what you're describing would be a situation where criminal conduct arguably has occurred. So, provided that the law enforcement agency becomes aware of the situation through notice or a report, I think given the seriousness of the allegations, that law enforcement would investigate.
Thank you. I do have further question, but not for Mr. Parr, Madam Chair.
Thank you. Okay, so I'm just trying to reach people who have not yet participated in the conversation. Representative Poirier, go ahead.
My question is just in general. It's not for Mr. Parr.
Okay, so thank you for pointing that out. Is there anybody who has a specific question for Mr. Parr? Please raise your real hand. Okay, go ahead, Representative Thorne.
Thank you, Madam Chair. I don't know if you're or anybody else is aware how often this is exercised currently. I mean, I'm trying to think of how much of an issue this is currently, how often the police or a parent goes to a school and requests bus video or classroom. Do classrooms have videos? Some do, some don't.
I guess I would answer the question this way. I don't know how frequent this is an issue where these records are sought. That's simply not something I know. I know that this committee, I believe Representative Babbage has, we talked about the weaponization of information, and this, it's if the press can get access to this, then anyone literally on the planet can get access to this type of material, including for purposes that Representative Rackett talked about, potentially for stalking, also potentially for online bullying by one student against another for whatever reason. So I think that with just the proliferation of information and the digital age that we're in, it's something that I think is bound to happen. And I would understand that the intent of the bill is to be mindful of that and do something proactively.
Thank you, Mr. Parr.
Madam Chair, and I guess just to voice my concerns at this point, is it seems that a motion has been made, but I'm not comfortable. there's too many loose ends for this and too many questions that are unanswered, I guess, for me at this point.
Thank you, Representative Thorne. Go ahead, Mr. Parr.
I just have an observation, and this is as someone who has been on the Right to Know Advisory Committee, and we have considered, this issue in the past. A couple of things, in addition to the 3 comments. First, I'm not sure that a bill can restrict a private person's ability to do whatever they want with a video they make at home. If we're talking, though, about videos that are recorded and maintained by a school, for example, then as I understand it, because I have 2 kids, it seems like those would be predominantly classroom activities where you see students and so on and so forth. And I think that would be, I tend to think that those type of recordings would be covered by FERPA. In addition to the comment I made about maybe if something were expressly stated in the bill, as far as law enforcement access and parental access, another approach could be that access would still be allowed by potentially anyone, but the ability to obtain a copy of the video so that even a member of the press could perhaps go in, review the video on site, but they wouldn't be able to obtain a copy of it absent, and there might be a mechanism where a court order could be sought, or where an appeal could be sought of that decision of the, hey, we've seen something in court and for good cause, we think that it's appropriate for you to review the video in camera and decide whether or not it should be released publicly. And likewise, again, there's always that question of access versus providing an actual copy, right? And so one thing the committee might consider is, okay, maybe this should allow for access to whomever, whatever universe you want it to be, everyone, these particular, law enforcement or whatever. But in order for a copy to actually be able to be disclosed and potentially disseminated on the internet, then that would be something that would require further process. So just my thoughts as a Right to Know Advisory Committee member, and I'll be quiet now.
Thank you for sharing those thoughts in your capacity as a Right to Know Advisory Committee member, Mr. Parr. That was helpful. Committee members, I feel like we've got a lot of information on the table, and I would like to know if I feel like we should discuss as a committee, and I want to just make sure, are there any additional questions for Mr. Bailey before I move him back to the attendee list? Okay.
You have one.
Oh, go ahead. Senator Keim has one. Go ahead.
Yes, thank you. So, Mr. Bailey, has there ever been a time that you've been asked for video, because I think, this is where we're truly focused, that you had to deny the request for video, and or that you've given out video that's been problematic? I mean, I'm just trying to get an idea on this in Maine, because, the ACLU's testimony did go into FERPA and the fact that this law is unnecessary because we can protect students' private information. But you're the one that has this experience, I'm supposing.
Not me personally. I do know of situations where it has been requested in terms of the buses, and that's, I think, was raised earlier by Senator Carney in terms of the differentiation or by the analyst with regard to how does this apply to buses as it compares to within the school building. So that is one of the extending situations where we would want to have this be protected.
And so what happened in Pennsylvania is that they blurred out the images of the children, but still allowed the footage to be given out. Would that answer some of your concern?
No, it wouldn't. Not as a right to know, not to the press, or not to. It would not alleviate my concern with regard to being released to the press.
Even though you couldn't tell who the children were, you still think it's problematic that the press would have video footage?
Yes, I do.
And why is that?
There would be other potentially damaging situation or FERPA related information that could be identifiable based on the request or by the usage of the video.
Do you have any specific things you could give me other than just it could be used this way, like any other?
I don't have specific examples, no.
Okay, thank you.
Thank you. All right, Mr. Bailey, I'm going to send you back to the attendee portion.
May I ask Mr. Bailey one last thing?
Go ahead, Representative.
Thank you, Madam Chair. Mr. Bailey, I just wanted to be sure if a parent had been told of an incident between a teacher and himself, or between the student, the child, and another student, you're saying that that parent always has access to a video if they request it?
If there is a video of the situation and the situation would be valuable in terms of context of discussing the situation, and the it's not within an employee, but it would be of their child, that they would be able to request access to be able to see it.
Is that in statute, or is that policy, or
no? It would be school procedure. It's not in statute.
Okay, but normally wouldn't it be access to see it, but not given a copy?
That's correct.
Thank you. Thank you, Madam Chair.
Thank you both. All right, Mr. Bailey, I'm up. Go ahead, Senator Kime.
I'm sorry, his answer just confused me. So they could request access, but the school also has the ability to deny it. Is that what you're saying here as well, depending on the circumstances?
Yes. That would be worked out between the parent and the administration in terms of the situation, whether or not it would be possible for the protection of other students to be carefully taken care of in terms of viewing the situation within the video.
All right, I'm going to send Mr. Bailey back to the attendee space, and also Mr. Parr, so that we can commence with our committee discussion and move on to a vote. All right, I see lots of hands raised. I'm just going to interject one thing, which is that I thought Mr. Parr made some really helpful suggestions, including that, and I think we should consider an amendment that would include in both of these, express that law enforcement and custodial parents or guardians have access to the video and audio recordings. I think that that's a really important protection for parent access. So I'll just make that suggestion. And Representative Poirier, go ahead.
Thank you, Madam Chair. I just wanted to say something because I've been part of the school district here in Skowhegan SAD 54 for 11 years now. And I just can't, in my mind, I think other districts probably do a lot of the same things that my district does. And I believe most districts probably have policies about this sort of thing already. So I find it hard to believe that we really need a law about this. In the instance that you, Senator Carney, talked about as far as having students fighting on the school bus, I can tell you exactly how it would be handled in my district. If there were two students fighting, chances are the parent would not be allowed to see the video because there are two students being identified in the video. The school administration will view it, and the parents would be told what happened. But because there are two identified students, neither parental party is going to actually physically see the video. If there was law enforcement involved, then perhaps they would through law enforcement. But if it's something that's going to involve any sort of disciplinary action just in the school, then no, parents aren't going to see it. That's a policy of the school for student privacy. Student privacy always comes first. So, I mean, before I were comfortable voting this kind of bill into law, I would want to know what kind of policies other districts have. Do we really even know what policies school districts already have in place to know if this is a necessary law? That's my concern right now.
Yeah, and I think that basically, even though you're saying that the freedom of access law, which defines basically every record as a public record, unless it's listed in an exception like W or X, would be something that would actually, in some ways, for example, in the school bus situation, I believe, supersede the school policy.
My superintendent says no frequently because of student privacy. And I assure you, most superintendents are probably going to do the same. That's why I would want to know what other districts are doing already.
Okay, thank you.
Thanks.
Okay, so I see 6 other hands up, and if I can I'll call on everybody. Please just, if you can express your views of the bill, and then let's decide if we're ready for a vote. And I'll start with you, Representative Libby.
Thank you, Madam Chair. I have many concerns, some of which would be addressed by making sure that custodial parents would absolutely have access. I see nothing in this bill as it stands right now that indicates that they would have access at all. I think that seems like a pretty big assumption that they would be made exceptions to this law when it doesn't say that. So an amendment would be incredibly important. I still wouldn't vote for the bill, however. I have underlying concerns. I think not only parents need to have access, but press. There have been too many cases just in the last year alone where press has helped to bring transparency and accountability to those in authority, particularly in school. And I would not want to see that safeguard gone. I think that there are many ways that we could handle this issue. And I do appreciate that several of them have been brought up. I think that this bill is not the answer. We could put something in regarding blurring out, making images unidentifiable. I don't think that Mr. Bailey sufficiently answered that question as to why that would not be an acceptable answer. Technology exists to make that very simple these days. We could have the other option where people could go in to view the video. It doesn't have to be disseminated. I think there are a lot of possible answers here that could help protect students. And I think that this bill will do the opposite, but not protect students by decreasing accessibility, transparency, and accountability. And I hope that it is amended if it passes, but I will not be voting for it regardless.
Thank you, Representative Libby. Go ahead, Representative Evangelos.
Thank you, Madam Chair. Madam Chair, you probably can answer my question. I don't want to belabor this. I got in a little late because I was traveling back from Augusta. Is Judy Myers still standing by her original testimony?
I believe she is. She is in the attendee room, but we've kind of.
Yeah, it's a yes or no question. Is that your recollection that she's standing by it?
She has not indicated that she's not.
Okay, that's all I had. Thank you.
Yeah, to my knowledge, but I haven't heard from her since the original hearing.
I'm good, thank you.
Okay, let's see, Senator Keim, go ahead.
Thank you. Yes, I believe that to move forward with this bill is based on very thin evidence. Mostly what I would say is a lot of people saying they would like to proactively deny access to protect from scenarios that have been surmised, but none of them have actually happened. And the Pennsylvania issue that was brought up, the students' faces were blurred, and I'm not sure that any negative impact ever came from that case. And yet Mr. Bailey said that was sort of the crux that brought this bill forward. I'm concerned a little bit about our process here on this bill, because we've heard extensively from Chris Parr as part of the Right to Know Advisory Committee, who is obviously in favor of this bill, extensively him offering his comments and his perspective and his observations and his opinion, but not anyone on the other side. So our balance in our work session has been very much towards in favor of the bill, with nobody in opposition.
Excuse me, Senator Keim, I'd just like to interrupt you there for one moment, if you don't mind. We pulled Christopher Parr in because he was requested by Representative Hagan to answer a question about law enforcement. If there is somebody who you would like to bring into the panel, I am truly happy to do that. I can't remember who asked the question that caused us to bring Stephen Bailey in, but I was not selectively bringing people in from the panel. I was bringing people in, again, who committee members asked, indicated they had questions for. So we can definitely pull somebody in if you'd like. So just let me know. Thank you.
Fair enough. I think that it would be helpful, and I don't know if Judy Meyer is still here, but because we talked so extensively around what happened in Pennsylvania, and then thinking that's what, extrapolating that somehow that was negative and would happen here, I think it might be helpful to hear from her. But I do think that safeguards for children are important, but what we've seen so far is that the access that we give the press to video has helped us see really important things that have damaged children being mistreated, or children being put in danger by bus drivers. And so to have real life examples where we've seen the video be helpful, then to surmise that we'd be protecting children by removing access to video, we have really strong testimony that shows us that FERPA is a protection for personal identifying information. And I would suggest that people's faces is personally identifying information. And ACLU says this bill isn't necessary. I am really concerned that we always have our public systems be accountable and be transparent, and the taxpayers pay for these systems, and therefore we have the right to make sure that what is happening to our children and in these systems is open and available for everyone. And so that's a long statement of why I'm opposed. I do think that in the balance, it might be good to hear from Judy Meyer, but I would ask that if she has anything substantive to add, that she would raise her hand, and otherwise I think it's not necessary. Thank you.
Thank you, Senator Keim. So I'm going to ask the committee members if there is anybody who has not made up their mind on how they stand on this bill and would like to hear from Ms. Meyer in order to decide how they're going to vote on this bill, please wave your real hand. Representative Libby, I thought that you had indicated that you were voting against it regardless.
I would appreciate hearing from Ms. Meyer in regards to if there is an amendment, if that would resolve her concerns.
And Representative Sheehan, you also raised your hand. Do you have a question for Ms. Meyer as well?
I actually I'm more concerned with Megan Sway's take on it, but while you all speak with Judy Meyer, I can revisit ACLU's testimony.
I've just invited Ms. Meyer to rejoin the panel. Thank you so much for joining us today, Ms. Meyer. And Representative Libby, why don't you go ahead with the question you wanted to ask Ms. Meyer in order to determine your vote on this bill?
Thank you so much, Madam Chair, and thank you for being here today, Ms. Meyer. My question is, I'm sure you've heard the ongoing discussion and the question of a possible amendment to this bill regarding parents, custodial parents, and law enforcement having access to the videos. Would that allay your concerns regarding this bill, or would you still stand by your testimony of the public hearing?
Thank you for the question, Representative. I would still stand by my testimony. When this came before Right to Know, it is considered a proactive measure based on a single case in Pennsylvania where a student was being dragged and there's a disciplinary action against a staff member. And ultimately, Pennsylvania decided to let the videos remain public, but to be blurred out. This bill goes far and beyond that. And further, when Right to Know considered this, we asked Maine School Management how many videos have been requested of Maine schools. How significant is this problem? And Maine School Management was not able to answer that question because that data is not tracked. So we really don't know how many FOA requests have been made for video, if they've been granted or not, because nobody has kept a record of that.
Thank you. Ms. Meyer. Representative Sheehan, did you also have a question for Ms. Meyer? No? Okay. Committee members, does anybody else have a question that they need to ask Ms. Meyer in order to figure out how they're going to vote? Go ahead, Representative Babbage.
Yes, thank you, Madam Chair. Ms. Meyer, I guess what I'm looking for, I know Right to Know, I think Mr. Parr expressed it, we're either deciding to side with privacy with exceptions, or we side with public access with exceptions. I mean, that is how the Right to Know Committee framed the issue. So I guess what I would like to do is know what exceptions might be appropriate in this case. So in this case, if we're going to shield information from becoming public, are you saying, you know, I'm wondering what kind of exception might permit a custodial parent, law enforcement, and perhaps the press from at least having access, although not use and distribution capability of that information. What do you think? I mean, do you have a suggestion for us?
While it would certainly improve the bill if those exceptions were made, I am in the camp that FERPA already very much blanketly covers this. FERPA rules student privacy, and other states use FERPA to deny access to video. Maine has done that in the past. And I think that's really all the protection that a student needs in our schools right now. It is the overarching protection for student privacy.
Thank you for that. Although I gotta admit that I came in late in the conversation and my knowledge of FERPA is very, very small. But I appreciate the answer.
Thank you.
Thank you, Ms. Meyer. And I think that, and Representative Babbage, Representative Moriarty, do you have a question for Ms. Meyer as well?
No, I don't.
Okay. And Representative Poirier, did you have a question for Ms. Meyer? No. Okay. All right. I think that don't have any additional questions. Thank you so much for joining us today, Ms. Meyer.
Thank you for the opportunity.
And okay, committee members, I think we were doing a final round of comments before moving on to a vote. And let's see, Representative Moriarty, and go ahead.
Madam Chair, requesting a corner caucus not to exceed 3 to 4 minutes.
All right, we will. So it is 3:19 right now. It's weird to do 3 or 4 minutes. So
Well,
let's resume recess until 3:25. Everyone. All right. See you at 3:25.
Is anybody there? I missed what's going on right now.
We're on break
Yes.
Okay.
They're
till
caucusing.
25.
Are we meeting or no?
Nah.
All right. Thank you.
Oh, I got 3 minutes.
I have to say to myself, you're muted, Anne. I was just talking to all of you. Committee members, if you could please activate your audio, your video, excuse me, so that we can resume our work session. Looks like there are quite a few of us back, but not quite everybody. All right. Nearly all of us are back. So Representative Moriarty, your hand is raised. Go ahead.
Yes, Madam Chair, I have made the motion not to pass. I offer now an amendment to that same motion to include the following language at the end of both subparagraphs W and X. The language as printed would end with a comma, and the following language would be inserted. I'll read it slow for Peggy and Soupy. Provided that law enforcement authorities and custodial parents and guardians shall have access to the designated video and/or audio recordings.
Thank you, Representative Moriarty. And Representative Reckitt, you seconded the initial, the original motion. Are you seconding the amendment? We're not able to hear you, Representative.
Yes.
Thank you so much. So we have now an ought to pass as amended with the amendment proposed by Representative Moriarty. Is the committee ready for the vote? It looks like we are. Go ahead, Soupy, you may call the vote.
Thank you, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Kime. Sorry.
No.
Was that a no?
It's a no. Sorry, I was looking for my button.
Senator Kime votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
No.
Representative Galgay-Reckitt votes no. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
No.
Representative Sheehan votes no. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Can someone please restate the motion for me? I am just wanting to be sure I have my vote right. This is not going exactly as I thought it was.
The motion is an ought to pass as amended with Representative Moriarty's amendment adding express access for law enforcement and custodial parents or guardians.
Thank you for clarifying, and my vote is no.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Newell. Representative Newell is absent.
Madam Chair, I have 3 members voting in the affirmative, 8 members voting in the negative, and 3 members are absent.
Thank you very much, Ms. Panett. And for those who voted against the pending motion, could you please state what your report is? We can start with you, Senator Keim.
Mine would be ought not to pass.
Okay, and yeah, that's a great idea, Representative Thorne. If you are straight ought not to pass, raise your hand so that we all know who's on that report.
1, 2, 3, 4. 1, 2, 3, 4, 5, 6. It looks like everybody that voted against the motion is ought not to pass. Is that correct?
That is what I saw as well. And Senator Keim, is that your observation as well?
Okay.
Great.
Well, that makes it very easy. Thank you very much.
All right, so we've concluded the work session on LD 331 and wish to thank the sponsor very much for bringing the legislation forward. And now we'll move on to a work session on our next bill, which is LD 864. This is the teacher privacy bill, and the title is An Act to Protect Teachers' Privacy While Delivering Remote Instruction. And Peggy, if you would like to go ahead with your analysis. And Peggy, did you get an amendment from the bill sponsor? Did you receive an amendment from the bill sponsor?
I did not. Okay. Like you, I've been getting tons and tons of emails. So if she sent it to me, it's possible that she sent it and it's buried.
Okay, she did send it to me, and I think what we'll do is
I have it too.
Okay, yeah, because I think I just sent it to you.
Oh, okay.
Rickett. So I can screen share it, but if committee members feel like this is that we're just getting this and we haven't had enough time to kind of let it sink in, then we can table the bill. But is everybody okay with going forward to at least look at the amendment?
Yeah, so this is LD what?
This is LD 864. Okay. And then Peggy, do you want to give a kind of a top line analysis, and then I'm going to try to screen share. I don't know if I'll be successful, but we'll try.
Okay, so the bill is written amends the education statutes to address remote instruction. It defines what remote instruction is, and it also defines an unauthorized person to mean any person who has not been authorized by a public or private school to participate in remote instruction. And then the bill goes on to prohibit an unauthorized person from accessing, viewing, listening to, disrupting, or participating in remote instruction. It also, it doesn't prohibit incidental viewing. It also prohibits, as otherwise authorized, a person may not make an audio, video, or digital recording of a real-time transmission of remote instruction without the express written consent of the public or private school. And it includes, it makes it a civil violation. So it basically prohibits being part of the remote instruction if you're not an authorized person, or recording or transmitting the remote instruction.
Thank you very much. And I did just hear that, and the bill sponsor has arrived, and I think maybe we'll let her speak to the amendment. And Peggy, if I need somebody to help me walk through how to screen share it, I will rely on you, but let me bring the bill sponsor over first. That is Representative Dodge.
If you want to email the amendment to me, I'll be happy to screen share it.
Okay, I will do that.
If that's easier.
Yep.
Good afternoon, ladies and gentlemen. How are you?
Do you ever stop smiling?
I'm not
Just
sure.
a question. Just a question.
I try to find joy in every minute
Every-
of every day. Thank you for the opportunity to speak to this amendment. If you would like to screen share it, I believe it has been sent to the committee. Is that not correct?
Hang on, we're doing that right now. Just give us one moment, please. And Representative Dodge, I think you're probably aware that they're, at this point, we are all doing 100,000 different things all at once. And so I think that you were so kind to send me the amendment, but I don't think that it has been shared with the committee yet. So we're going to screen share it and then allow you to talk us through it.
So the definitions remain. Section 2 has been eliminated, and we have retained parts of the recording prohibition. And those are the changes in response to some of the concerns that were expressed in the public hearing. I'll give you a moment or two to digest if that would be helpful. And I believe John Kaczynski from the Maine Education Association may be able to walk you through the specific applications and implications if that would be helpful.
And just a question, Representative Dodge, it looks like paragraph 2 is maybe the heading should be changed because it's not it's prohibiting distribution. Is that correct, rather than prohibiting recording?
That is correct. Distribution or retransmission.
Okay, so let's see if Mr. Kaczynski is here. And he has not joined us yet.
Sorry.
Peggy, thank you for making the change.
Oh, thank you. That's wonderful.
Help if I spell it right. I did. Distribution. Okay.
And so essentially what this proposed amendment does, Representative Dodge, is to require somebody who's going to distribute or transmit a recording of classroom instruction to essentially get the permission of the school to do that.
That is correct. And that is what is currently in place for regular instruction within a school. Folks would not be able to come into a classroom without the permission of the teacher, the principal, and the appropriate parent releases.
Thank you.
You're welcome. Thank you.
And committee members, are there questions about this proposal? If you have questions, just raise your electronic hands because then you'll pop up on the screen and I can see you. Representative Reckett, your hand was up first. Go ahead.
Yes, I'd like to move ought to pass.
As amended?
As amended, right.
Thank you, Representative Reckett. Is there a second? And I'm not able to see. Representative Thorne, your hand is raised. Is it raised for a second or for a different purpose?
No, not for a second, Madam Chair.
Okay, let me scroll through and see if there are, Representative Moriarty has seconded the motion. Okay, and
Do you want me to stop sharing?
Yeah.
Yeah, I think everybody's had a chance to look at it. Thanks, Peggy. All right, so we have a motion ought to pass as amended And a second, and then Representative Thorne, go ahead.
Always amazes me. I think I know what committee procedures are on a work session. And the first thing that comes out of anybody's mouth is an ought to pass as amended motion before we have an opportunity to discuss it.
Let me clarify the procedure, Representative Thorne. So we can
Please do.
discuss it even after a motion, and actually often you discuss it after a motion has been made. So you can discuss
Right.
with your discussion.
My question is, now I've even forgotten my question, but it doesn't prohibit or interfere with parental supervision of a class any more than it currently does, correct? That's not going to change. If a parent wants to go in and observe a classroom, they're either allowed or they're denied for whatever viable reason. And that would still apply for observing a remote classroom presentation. They would just need to get prior permission, okay, to do that, correct?
It's my understanding that they don't need prior permission with the amendment.
Okay.
That parents are always in, well, I should let me clarify that as a teacher. Parents are often involved in their students' education, and that's encouraged by teachers. And I heard your concerns around that, and that's part of what drove the amendment language.
Thank you.
You're welcome.
Do you have any follow-up, Representative Thorne? False.
No, that was my one and only question. Thank you, Madam Chair.
All right, thanks. Representative Hagan?
Yes, I was thinking of making, thank you very much, Madam Chair. I was thinking of making a tabling motion, but I think that I would like to have a corner caucus of 4 or 5 minutes. Usually, as you may or may not know, I don't like getting amendments to videos, where's my head, to bills and then having to vote a few minutes later. So if I could have a few minutes to chat with my esteemed colleagues, and then that would be great.
Okay, so let's return at 3:50. That gives us 6 minutes. Thanks, everyone.
Peggy, who made the motion, please?
Soupy, I can answer that question.
Oh, I'm sorry.
Lois,
I didn't realize I was muted.
yeah, Lois made the motion and it was seconded by Steve.
Thank you so very much.
I'll be back in a moment.
I was telling you I was just muted.
I'm laughing, Peggy.
We had a knock on the door and I had to go answer.
Oh. Thank you. I appreciate your amusement.
Thank you.
Excuse me, please. Would it be possible for the link to be resent to John Kaczynski from the Maine Education Association, please? He's not able to access the meeting now.
Supi, are you going to do that or you want me to do that?
Is his email in the system?
It should be.
Okay. Hold on, I'm opening it up. And it's spelled with a K?
Yes. J. Kozinski, Kosinski.
I don't have it in my Kosinski.
That is correct. Kozinski.
It's not coming up in the global peg.
That's okay. And do you know where he is?
He's at the Maine Education Association.
MEA.
Oh, that's why. Sorry, that's my
Right.
fault.
You're just going to have to type it in. So
Thank you very much. I'm sorry for the request.
it happened, technology is wonderful.
When it works. And also, did I not follow appropriate procedure by submitting the amendment to the chairs and to the clerk, I believe?
Oh, that's fine. I think it's good to send it to the chairs, and if you send it to the clerk, she's not sure if it's going to everybody else. And then, there's just so much going on. I think you're fine. Don't worry. We'll get it to everybody eventually.
Well,
I gotta grab my phone.
If I had slipped up in procedure.
Don't worry.
Okay, thank you. It sounded that way from the representative.
I know that they do like to get, things I draft, they like to have at least 24 hours in advance. So we do the best we can. So
thank you.
Thank you. I will read it and enjoy reading it, and I appreciate it. I'm glad we both voted 4-3-3-1. But I need to have time to go into this before I actually make a vote. So I am going to ask for a table motion. And I was a yes vote on this bill coming into the amendment, but now I don't know.
Did I mute him?
I have to get into it. But effective today,
I can't mute him. I'm not a host. Sorry.
No. I don't know if he was
Open
trying.
discussion.
Yeah.
Representative Hagan, were you engaging in public discussion that should have been online or private discussion?
No, Representative Babbage, the kind and wonderful man that he is, sent me the amendment. So thank you. I really appreciate that. It was a very kind and nice gesture for him. But so am I up, or are we not back yet?
Let's let the kind and wonderful Representative Babbage join us as well as you. I don't know if I exactly quoted you, but let's give him a moment. All right, it looks like we're all back. And you have your hand raised, Representative Hagan. Go ahead.
Yeah, I like the bill, and but as with most things, when I haven't really read a brand new amendment, then I vote a few minutes later. I'm uncomfortable with that. So whether I win or lose on my table motion, I'm making a motion to table.
Okay, a motion to table is non-debatable, but there's a second, Representative Libby. Okay, and so And yesterday, somebody raised a concern about the fact that members of the public who are viewing can't see our electronic hand raising process for voting on tabling motions. So I'm going to ask our committee clerk, Ms. Panett, if she can actually call the vote on the tabling motion, just so that it's really so that the public can see it.
I would be more than happy to. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
No.
Representative Galgay-Reckett votes no. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos. Seeing Representative Newell. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Evangelos. Representative Evangelos is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 1 in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. So the tabling motion on LD 331 carries 9-1. And with that, we will close our work session. Actually, before we close the work session, I wanted to ask you, Representative Hagan, if there was any additional information you needed for when we resume to have a work session on this?
No, I just want to go over it, make sure that everything's kosher in my mind, and then ready to go.
Okay, thank you so much. And so with that, we'll close the work session on LD 331. Oh, no, I don't think we're on 331 anymore. Excuse me, on LD 864. And thank the bill sponsor for bringing the bill forward and being with us today.
Thank you very much. Good luck with the rest of your afternoon.
Thank you. Okay, and then the next set of bills that we have scheduled for our work session, it's a kind of a big chunk. It is what we've noticed is several of the remote participation bills, but we actually, I think we can put on the table here as well LD 32, which is another one of the remote participation bills that was offered by Senator Stewart. But we have LD 668, 746, 1224, and LD 32. And with regard to these bills, we had a very robust conversation when we did our first work session. And we don't have anything yet for the committee to look at. And I would just recognize Senator Keim, if you are able to suggest a path forward for using our time this afternoon and going forward.
Thank you, Madam Chair. Yes, I would like to propose to the committee. Several times in years past, we've tasked subcommittees to handle issues that we felt needed sort of a deeper dive, and as a way to help move our committees forward with the work that we had. And so I was wondering if the committee would be in favor of allowing Senator Carney and myself to look through all of the bills and try to come up with an amendment that we feel the committee would appreciate working with Peggy. And then we could obviously bring that forward and have the full committee discussion on hopefully one bill that might address all the different areas. But before going forward with that, I know that we would both appreciate if every committee member would make 1 or 2, encompassing statements, but maybe not really delve into, lengthy detail, but would tell us what they feel is their most important objective around the idea of remote participation, just so that and Peggy will take notes, and that we'll try to make sure that we encapsulate those concerns. I don't see this at all as a partisan issue. I think that we all recognize where we're at right now with the need for remote participation and the need for transparency and participation. And so I think weighing all of the interests involved is important, but somewhat time consuming. So if the committee is agreeable, I think that would help us move our work forward a little bit easier. And then, of course, I will reiterate that we will be discussing and making sure the amendment has a full, work session, and we discuss where we are with that, obviously in front of the public, and all of you will, weigh in at that time. So that is my suggestion of moving forward. If committee members are amenable, I would be happy to work on that and do that.
Thank you, Senator Keim. And I personally think that that's a really excellent suggestion, and I appreciate you bringing it forward. Are folks okay with that, committee members? Seems like everybody is. We've got a couple of hands up. Are you, Representative Babbage, is your hand up to discuss the process or to volunteer your version of the most important objectives? Because I'm going to call on people.
I wanted to appreciate Senator Keim and Senator Carney for I think what is a very smart path forward, and I appreciate them willing to do that. I think that's exactly the right thing for us to focus on one bill and then either amend it or not as a group. And those of us that may not be in a place where we can support it, we would be able to express ourselves. But I think for efficiency, I'm fully on board. At some point, I would like to talk about my 2 or 3 most important considerations, but so thank you.
Wonderful. Thank you. And Representative Moriarty? We're not able to hear you.
Sorry. I think our job is to pour a foundation, build a framework, and our guiding star should be local control.
Okay, is that your 1 or 2 most important?
Yes.
Okay, I'm gonna.
Can you say it again? Please?
Yeah.
Okay. Pour a foundation, build a framework, and ensure that local control is our guiding star.
Got it.
Thank you, Representative Moriarty. Representative Hagan?
Thank you very much. I would totally agree with the amazing mind of Mr. Moriarty.
Thank you, Representative Hagan. Representative Libby.
Thank you. I think this is absolutely the best course forward. I do appreciate Representative Moriarty's sentiments, but my chief concern is that the people's voice is heard and that it is not diminished by only having remote participation available.
Thank you very much. Representative Sheehan, you're next.
Thanks, everyone. And I wanted to let everyone know, too, how much I enjoyed the previous conversation that we had about this issue. I just loved having that kind of bipartisan exchange, and everyone was super thoughtful. So thank you. I agree with everyone, and I think local control is important. I want to make sure that we don't roll back the increased access that we have achieved by introducing remote participation for folks who have trouble getting physical access. I lived on an unbridged island for a year. It can be a big challenge for folks in those areas. And I also know some people with mobility concerns who have had greater access to public meetings and participation than ever before. On the other hand, I think a lot of folks, as Representative Poirier brought up, have experienced diminished access without having a physical place to go. And I know that that is a big ask, but I think it isn't too much to ask that older folks or people without good broadband access, or people who just, maybe need in-person for whatever other reason, should be able to have a place to go to.
Thank you very much, Representative Sheehan. Representative Thorne?
Thank you, Madam Chair. And I'll just first ask if Representative Hagan has any bills coming before this committee anytime soon?
I hope not.
Okay, I'm waiting for my good marks. I would echo Representative Sheehan's comments that, again, this is a bipartisan issue. Obviously, it's something that we looked at many people speaking as proponents for. And again, my only concern is that the remoteness doesn't overshadow the in-person aspect going forward. What we're in right now is hopefully temporary. We've built and established some rules for remote participation, but I would make sure that the emphasis is on the ability to versus making remote participation, the rule. It should be the exception, as long as that's emphasized. Thank you.
Thank you very much. So who hasn't weighed in yet? Representative Poirier, would you like to weigh in?
Sure. Just to echo that as well, the in-person as a standard and the remote as an emergency option or an addition to the standard in-person is my number one priority. But also keeping a standard in there of transparency. Any procedures need to be transparent in the virtual world. As a person on the outside viewing what's going on in a virtual meeting, the transparency is a must. So that's something we really need to include in any kind of policy, whether we're giving local control or not. That's something that really needs to be a standard, in my opinion.
Thank you very much. Representative Babbage?
Yes, thank you very much, Madam Chair. The last time we spoke of this, it was very late in the day, and I think I was getting a little strident. And if I was, I apologize to all. I will say I've been fighting to legitimize remote participation for 4 or 5 years, but I've wanted to do it without, opening the door wide open so that access would be sacrificed. And I'm talking about the kind of access where you can have a personal conversation before and after the meeting, the kind of follow-up questions, those kinds of things that the public does with their elected officials, as well as being there and being able to petition their government, And so I will point out an amendment that I distributed at the 11th hour. I know, much to Representative Hagan's chagrin, and I understand that totally. And what I think where I'm at is the opening sentence kind of tells you that I'm philosophically, but I've made it more permissive. And what I mean by that is I've still asked for us to address the issues of quorum, which I think is most important. Should there be somebody at a physical space? um, each member, even if they participate remotely, must be accountable in person at least once a year, the annual meeting or whatever. Each member of the public body who is participating remotely have access to all materials and can be heard and seen by the public. And then finally, executive sessions. I mean, there is an issue of confidentiality. If you're being spoken about in a very, maybe it's a personnel matter, or if it's something more serious, the confidentiality aspect of remote is very difficult. And that may be something that people choose to override. So what I've done is I've outlined those things that I think should happen, which would be much more flexible than what was done previously, but that if they choose to divert away from the prescribed suggestions, that it face the voters so that they can at least be knowledgeable and be fully cognizant of how much access they're going to have and how that's going to be done. Other than that, I think it's consistent with everything else that, so I appreciate it and whatever can, so for me, I would say the same things that Representative Moriarty did, and that is provide the framework, but flexibility and local control will ultimately prevail. The only difference I would say is if they're making certain changes other than we suggest, that local control go actually to the constituency so that they can approve. Thank you very much.
Thank you, Representative. And when you say that if there's local control, that it go to the constituency, do you mean that the people within the jurisdiction who elect the members of the body would vote on the policy? Is that what you're?
Please, thank you for that, because my bill is different than everyone else's in that I'm only dealing with elected bodies.
Mm-hmm.
And so I'm saying that a select board could look at our prescriptions, adopt them, and go forward, and it'd be easy as they'd still have to have a public hearing and then adopt the written policy. But they would only need to go to the voters if they decided to go with no quorum or a different quorum or with totally remote executive sessions all the time or whatever it would be, so that the people would know, be able to discuss it and give approval.
Thank you. Representative Reckitt.
I was waiting for Representative Babbage's 2 sentences to get done, so it took me a little while.
Yeah, compound complex.
I was going to set the 3-minute timer.
That's right. Anyway, my 2 concerns really are access, particularly for the elderly and disabled, of which I'm rapidly becoming both. And my observation that, as annoying as I find not seeing you all in person, it has been much easier for me, particularly in the dead of winter, to deal with my duties. And so I'm appreciative of the possibility of remote access. So I'm concerned about those 2 constituencies. I'm also concerned about statewide groups, because my observation has been that when you've got a group of people who are operating statewide, you get a whole lot better participation if you at least have a possibility of remote participation by, for instance, people in the county. And so I think that I'm interested in that piece as well as the island participation. So the people who are generally excluded from in-person meetings because of distance or travel.
Thank you, Representative Reckitt. And Senator Keim, you and I are the only ones who haven't weighed in with our 1 to 2 cents. And would you like to have the last word or the next to last word? Either works for me.
I'll let you have the last word. I have questions more that I feel like we still, I need to make sure that we figure out, which is if we're going to come up with a policy that is the foundation, as Moriarty said. There's so many different, like we have had bills that are about boards and so then we have these public boards, and then we also have elected boards. So I just think that we need to make sure that we are considering all of the aspects that they cover and whether or not they're receiving or spending public money, I think is a distinction as well. So those are some of the, I mean, I agree with a lot that's been said. I access and transparency are of utmost importance to me, but I also want to recognize that if we're going to create a policy, we need to make sure we're considering all of the different entities that this would be covering. And I know that Peggy will help us do that, but that part is important to me, and that's why I'm stating it.
Thank you very much. And actually, that's one of my two concerns too, is to really think through what's appropriate at different levels. So on the municipal level, you have maybe the town council, which is elected, but then you might have the conservation committee, which is appointed. And how do we differentiate between those? How do we get a statute that works appropriately for each of those layers? And then the other point that I would think we need to think about is access to written materials or documents, and ensuring that both members of the public and members of the body have advance access to the paper documents, or whatever they are, electronic or paper documents, that are going to be the subject of discussion at those meetings. Go ahead, Senator Kime.
Sorry, I just had one other follow-up, just for obviously people are listening that are interested in these bills about remote participation. So I just wanted to make the further comment that whatever we come up with for the committee's consideration, will be certain to get it out ahead of time and to the interested parties so that they can offer their feedback, hopefully in writing, to the committee ahead of time. So we have a lot of information to weigh as we consider any amendment.
Yes, absolutely. Thank you for contributing that. Representative Babbitt, your hand is up. Did you have something to share? Okay, residual. All right. Committee members, would anybody else like to raise a point that, having listened to everybody, maybe we missed, or are we all set with the points that we've discussed? Looks like everybody is all set. And so with that, I think we have concluded our second work session on the remote proceedings bills that have been presented to our committee. And Senator Kime and I will get to work with our committee analyst.
Madam Chair, can I say one thing?
Sure.
More, as usual, I'm sorry about this, but because my bill is about elected officials, that does not mean that I don't support remote for those other categories. The other categories, I'm even more flexible with how they want to do it, but I thought elected deserved a special threshold. That's all. Thank you.
Thank you. Peggy, did you have anything that you wanted to add to this conversation as our committee analyst? No. Okay, so it seems like our work is probably done for the day. Let's just check in with Peggy and Soupy to see if there's anything that they need us to take care of before we all return tomorrow at 9. Soupy?
We just going to not table the bills. We're just going to leave them.
Yeah. I don't know.
Reschedule.
Yeah.
If they're not open, Madam Chair, they don't need to be tabled, correct?
Yeah, I don't think.
Did we open
them off the table? I think we were just having a discussion.
Okay, that's perfectly fine.
Yeah, thank you. And Peggy, anything that you would like us to address before we adjourn tonight?
I don't think so.
Okay, good. All right, everybody, is there a motion to adjourn? Lots of them. All right, thank you, everyone. See you tomorrow morning.
Good night now.
Night, thank you.
Bye.
Right, everybody.
Ooh. Hey, Miss,
We're streaming.
saying goodnight. I'm closing you off.
Okay, bye.
I'll send you